तो नहीं आ रही चैनल में, यहाँ मैं लगाया हूँ केबल तो नहीं आ रही है। आप वायर एक बार चेंज करके देखो, टेस्ट करना माइक।
हेलो
नहीं आ रही है। केबल सेम है ना जो आपने पिछली बार दिया था। टेस्ट करना भाई।
हेलो हेलो हेलो
नहीं दिख रही है चैनल पे वे भी नहीं दिख रही है। टेस्ट करना भाई।
हेलो हेलो
ऊपर ही आ जाऊँ मैं क्या?
हेलो हेलो हेलो
चेक करना।
हेलो हेलो हेलो
प्रिंस देख रहे हैं, देख रहे हैं।
हेलो हेलो हेलो
हेलो हेलो, ये आ रही है ना, वेब आ रही है ना ऐसे। और इसको मैं जब लगाऊंगा तो माइक।
हेलो 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 आवाज़ आ रही है ना? हेलो
हिल रही है, वहीं से हिल रही है, यहीं से नीचे से ही, वो जो जॉइंट है ना वहीं से।
हेलो 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 ठीक है, अब तो आ रही है कंटिन्यू। हेलो हेलो
चेक कर रहे हैं।
हेलो हेलो
वो आएगा तो बताएगा ना, फिर मैं टिक मारूंगा। हाँ सर, ऐसे बुलाओ ना।
हेलो 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 किसमें दिक्कत है? हेलो 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 ह-
ऊपर डायरेक्ट जैक लगता बड़ा वाला, जो जैक होता है ना, ये नहीं लगता। तो इस वाले को दिक्कत है, इसका जो
बाहरी तो टूटी है यार, कहाँ से चलेगा।
कैसे वर्क किया था, इसका भी चेक कर लो, इसका भी चेक कर
ना वो तो सही
हाँ
होगा।
वो
लो। तो कभी कैसे आ रहे हैं?
किसी ने नोचा होगा इसे थोड़ी ना। वायर है इसकी तो टाके लगा रखे हैं, तो फटाफट ऊपर ले जा सर। सोल्डिंग मशीन हो गया ऊपर ऊपर। अरे इसकी तो तार ही टूटी है, तो चलेगा कहाँ से इसकी, ये ऑक्स की अंदर जो ब्लैक वाली, ब्लैक और वो रेड नहीं होती। हाँ वही तो मैंने खोल के देखा तो सामने ही टूटी है हमारी, टूटी पड़ी हुई है तो चलेगी कहाँ से। दूसरी वाली केबल है अपने पास, जो ग्रीन वाली है वो, उसकी भी तो साइड से वायर अंदर सोल्डिंग करके लेकर सीधा।
सोल्डिंग फिर से बोलना पड़ेगा और शायद है भी नहीं सोल्डिंग।
टेस्ट कर लो इसको, मैं तो ये करूँ खोल के इसको भी देख लो अगर।
पकड़ो पकड़ो इसे, जाओ फटाफट ले जाओ, ऑक्स निकाल के देना।
हेलो भैया हेलो हेलो कोई बटन है ओके हेलो ओके ठीक है हेलो नीचे एक ही रख दो बस काफी
दो रख देता हूँ
यहाँ पे भी नीचे वहाँ गिर जाएगा नीचे एक ऊपर रख दो काफी है बस Welcome all to IP Gyanshala 2025. IP का ज्ञान, innovation की पहचान. As we embark on this journey of ideas and innovation, let us remind ourselves of the words of our Honorable Prime Minister Shri Narendra Modi. Innovation no longer remains a choice, but has become an imperative. These words perfectly capture the essence of today's workshop. where intellectual property and technology transfer are not just academic concepts, but powerful tools to transform creativity into real-world impact. Together, let's embrace the imperative and make innovation our identity. A very good morning to all the esteemed dignitaries, distinguished faculty members, dedicated researchers, innovative scholars, and valuable industry partners present here today. We extend a warm welcome to the FITT IP Gyanshala 2025 IP Ka Gyan Innovation Ki Pehchan, the Intellectual Property Rights and Technology Transfer Workshop. This workshop is dedicated to equipping the academic and industrial community with the vital tools necessary to transform intellectual assets into protected, marketable value. My name is Ayushri, and it is my distinct honor to serve you as host for today, guiding you through the proceedings of this comprehensive workshop. Foundation for Innovation and Technology Transfer, FITT, the industry interface of IIT Delhi, has been at the forefront of fostering partnerships between academia and industry. FIT acts as the intellectual property management and technology transfer arm of IIT Delhi. Over the years, we have filed more than 1,700 IP applications and facilitated 200 plus licensing opportunities for technologies developed by the IIT Delhi community. Through the support of BIREC NBM initiative, the Innovation and Technology Transfer Office, ITTO, was established under FITT to support the IP and technology transfer initiatives at other academic institutions, incubators, and startups. So here we are. As you all know, innovation and creativity are the cornerstones of a knowledge-driven economy. Academic and research institutions generate a wealth of ideas and inventions with immense societal and commercial potential. However, without adequate understanding and management of intellectual property, many such innovations remain unprotected or underutilized. This FITT IP Gyanshala is designed to enhance awareness about the strategic use of IP in research and development and to foster a robust innovation culture within our entire community. To commence the proceedings and deliver the official welcome address, it is a distinct privilege to invite to Dr. Nikhil Agarwal, Managing Director, FITT IIT Delhi, on stage to enlighten us with the session of the workshop.
Good morning, everyone. In fact, I was just speaking to Dr. Namita, and she told me that we have received close to 600 plus registrations for this workshop, which is certainly a matter of delight for me, because we are hosting another workshop on AI tomorrow, where the total registration is only 350. This room can accommodate only 100 people, so you can see that there is a more interest in IP than AI. So thanks all of you for coming. But I think IP, without IP, the AI has no meaning. That's something which we have also understood. In the last few years, the understanding of IP in India has increased. Earlier, IP was like chalta hai, or what will happen if we don't do an IP. The concept of IP was not very clear. The concept of intellectual property was certainly unprotected. Even today, it has its own challenges regarding jurisdiction, regarding the filing, regarding the grant, regarding the acceptability of the patent, not only in India but also worldwide. But those challenges we are trying to overcome. Lately, the IP has started becoming the most important factor if you look at the global companies. I was speaking to one of my friends who is based out of Silicon Valley. He is an MIT graduate, and his son is studying at Berkeley, and both Indian, certainly Indian origin. So they told me that they have recently, he and his son has written certain codes and done some patent during the COVID time, and he is able to sold those patents to a New York-based company for $50 million, which was absolutely surprising. $15 million with the student, which is a third-year student in Berkeley, plus his father, of course, is little well known, but it is a lot of money considering it's a payment only for the patent what they have written and what they are able to file. So he says not about only the way that you invent, but also the way you protect your IP, the way you write your patent application, the way you demonstrate in your patent application how this usability of this patent can be there for various industry type. The way that you are choosing your lawyer, lawyers also need to get smarter. It's not only about protecting your IP, but also showing the industry that there are certain use cases that emerge. Because IP is only valuable when somebody is willing to buy it. Otherwise, just a certificate on the wall, it's just another resume entry or a LinkedIn entry, which is certainly not the benefit for anyone. So IP is beneficial when we are able to do a technology transfer. So if you look at the India per se, India is now the 6th largest in patent filing in the world. Certainly, we have come a long way because India was not the very high patent filer. And I was reading the statistics in the morning, almost 100,000, 1 lakh IP has been filed in last year. That is a 60% increase on year-to-year basis. And if we do a 60% year-to-year basis, then I'm sure within 2-3 years, India will be among the top 3. US, China, India will be among India can attain the leadership position at least in filing. Now the question comes in about the grant of patents. So approximately similar 65,000 patents has been granted last year. And earlier, the global companies, like if you look at the statistics worldwide, companies like Samsung, companies like Microsoft, they're all global companies which file the maximum IP at the global level. And they were the one also filing similar IP applications, because if they are filing in Europe, they will also file in India because they have to protect themselves everywhere. So they were filing applications, and more than the 50% applications were filed by the global corporations. But last year was first year where the Indian residents have filed more application than the global application, 55.5% approximately. So which is another a positive way to look at it, that how the Indians are considering IP as important. Not only the global companies are trying to protect their interests in India, but also Indian companies or Indian entities which are going forward. Now, if you wish to consider the relationship between university versus industry. So people always may think, those who are not from the IP background, they think that IITs are the high filing entities for IP, because we have so many professors, they are producing research papers, there is a technology being created, so they must be filing IP. That is also true, but at the same time you will be surprised to know the private entities are high filers of IP in the country. For example, TCS, Wipro are the highest patent, they do the highest number of patents in the industry. And then followed by certain universities, University of Hyderabad, University of Mumbai, certain IITs. In IIT Delhi, we file close to 200 patents a year. And our idea is to increase it by not only 10-20%, but at least 50-60% on year-to-year basis. So that's one of the reasons of organizing this kind of workshop, is to bring in people who are from the community, who are from outside the community, who are engaged with us. So during the whole day, you will understand the various aspects of filing an IP. Not only filing the IP, but how do you create an opportunity for technology translation. There are case studies where we have done the technology translation in the tune of crores. There are examples exist from IIT ecosystem, forget about the Silicon Valley, where there are inventors which are receiving lakhs and lakhs of royalty every year on year-to-year basis. So if it's in fact the filing an IP, and if you are able to create a use case, it is more beneficial than writing a good quality book, because royalty of the book is relatively lower as compared to the IP. So my honest request to, particularly from the IIT Delhi community, is that start thinking of protecting your ideas. Any idea you think is protectable, and if you are unsure, there is a team available to help you out. We have onboarded almost 30 plus law firms who are there to help you out, who are there to help you write the IP application, to provide you input. Some of these member of the firms will be here today to talk to you. We have an in-house very competent team, and the members who are all sitting there, they can help you in understanding the way that you can file your patent, the fast-track patent, the international patent, what is the method, what is the benefit you can draw from IIT, as well as what the benefit you can, as a startup, you can also draw certain benefit under DPIIT scheme, or particularly state, like UP state gives you some benefit if you're filing an IP. If you're registered in Noida, so you can draw upon up to ₹1,00,000 from the UP state startup policy. Internationally, if you are filing international patent, if you are in a startup, you can take some money back from the government of India. There will be also a representation from the Indian Patent Office, so they can tell you that what are the new technologies and ideas where the government is bringing in bringing the IP together. Today we have also done a high listing of our IP. Close to 800 of our IP are today listed on our websites, and which are available for technology transfer. So we are also actively reaching out to industry, MSME, international agencies, where there is a potential to a technology collaboration or for outright sale. So I am particularly pretty happy about the way the IIT Delhi the community is moving forward, because in long run, that certainly I know, given the experience of other international universities, the intellectual property will become your most valuable asset. It will become more valuable than your own bank account. I am telling you, your bank account will have whatever value you have, but the IP on your wall will be more valuable than any other asset that you will ever have. I will end with one story. Story I don't know is verified or not, but it's quite popular among the circles. So there was a gentleman who came to buy a Marlboro cigarette. Marlboro was quite famous in 1960s. Still it is. But at the same time he said, I want to buy a Marlboro. I want to buy your cigarette company. He said, yeah, okay, take everything. This is my factory, this is my car, this is my house, you take everything. And this is the X value you have to give. He said, okay, but I didn't like the logo of the Marlboro. I want to redesign the logo of Marlboro. He said, who says that I am selling the name? The name is mine. You can take every other asset you want. So the story, as I have said, whether it's true or not, but it's quite famous in the circle. It's the brand that matters. It's the IP that matters. The land and building, the infrastructure, the factory, the car, the houses, that does not matter. Because something which you buy only looking at the brand that you have. And your brand is valuable because you have a technology, you have understanding. So protect your ideas, protect your design, protect your processes, protect your technology, because that will be the most valuable asset that you will ever have and that you will ever own. And I'm sure that this workshop will provide you a glimpse of how how Fitt can help you out, how IIT Delhi can help you out. And my another request is that ask a lot of questions, whatever questions you have. The people who are coming for the entire day, our Dean R&D would be here in the afternoon. Our director himself will be coming in the evening session. So ask these questions to them. What are the things that is taking shape? And with your inputs, we can also suggest to the government, we can also suggest to the leadership from IIT that this is the way that we have to improve. So thanks again for everyone for coming, and I look forward for a very promising workshop today. Thank you very much.
Thank you, sir, for awareing us and for setting such an inspiring vision for FITT IP Gyanshala 2025. It is now time to delve into the core of intellectual property itself. Our very first technical session is titled IPR Simplified, the Pillars of Protection. To lead us into this fundamental discussion, it is our immense privilege to introduce a highly distinguished scientist and legal expert, Dr. Malati Lakshmi Kumaran, Executive Director and Practice Head at the renowned firm Lakshmi Kumaran and Sridharan. Dr. Lakshmi Kumaran brings a powerful and rare combination of expertise to the dais. She possesses over 30 years of scientific experience in biochemistry and molecular biology, specializing in areas like plant genomics. She has successfully supervised numerous PhD students and has more than 100 publications in international journals. Transitioning her deep scientific knowledge into the legal field, Dr. Malati serves as a registered patent agent and heads the life science group at her firm's IP division. She is actively engaged in preparing, filing, and prosecuting complex patent applications, especially in the crucial sectors of pharmaceutical, chemical, and biotechnology, both in India and internationally. She also advises clients on plant variety protection, biodiversity, and traditional knowledge. Her unparalleled insight into both the lab and the courtroom makes her the ideal authority to simplify and explain the essential pillars of IPR for all of us. Ladies and gentlemen, please join me in offering a warm welcome to Dr. Malati Lakshmi Kumaran as she begins her knowledge journey. Ma'am, the stage is yours. To you. You want this mic, ma'am, or you want to speak here? This mic is also here. You can switch this.
No, I'm okay. What is there? Yeah. Thank you, IIT Delhi and especially Fitt, for giving me an opportunity to make a presentation. The topic given to me was IPR Simplified, Pillars of Protection. Being the first speaker, I think I can talk a wide range of topics. It's quite an interesting subject, and I think already you've understood why we need to protect our inventions. Yes, there is always a financial gain to protect your innovations, but also it is to get a monopoly so that when others copy, you get royalties, or you can have an infringement, you can get damages, and so on. And most of us think that IPR protection is only with respect to patents. And just to say that it can be patents, it can be designs, it can be trademark, it can be copyrights, it can be plant variety, it can also be GIs, and so on. And therefore, you need to see that it's just not patents, but it could be design. Why do I say designs are also very important? Is because if you know about the Apple versus Samsung case and huge damages that Apple got was on the design. The design of the phone, and you have that rounded edges, and it was the design, and the design is only as an aesthetic value. I mean, I like it, and therefore I get a design. The design of this iPhone was not for the functional aspects. It was not that Apple phone could do better than others or better than Samsung, but it is how the look and the feel. So if I want to get a design protection for my glasses, for my thing, or my jewelry, you go and protect it by designs. So a lot of protection can be done. It's very easy, it's very simple, because you don't have to give what its property is, what its function is, and what is so on. What you need to give is the look and the feel. I like this design, and therefore I can get it. And so if you just take a phone, you can get a design patent on it. Some countries call it as design inventions. Design patents is what they would call in the US. You can get a trademark, because the minute everybody knows that you can get a trademark. And just before you did hear about Marlboro, I think there are several examples that people sell the trademarks. There was a very famous case called the Jet. So there was a person in Madhya Pradesh, I think it was Indore, where he had a mosquito repellent, and the trademark was Jet. After some time, Godrej came in, and they were getting into this mosquito repellent area, and the Jet had a very good brand name, and everybody started saying Jet means mosquito repellent, and they bought the trademark. They did not buy the technology in the mosquito repellent, but he was stopped from using that brand name Jet. Now, Godrej got they paid few million rupees to get only the trademark, Jet. And what happened? They could go into any other business, but not mosquito repellents, and they could not use the name Jet. But Godrej would use the name Jet and use any other technology in the mosquito repellent. Same with Surf. Over the years, the Surf powder, which is your cleaning powder, it would have changed, correct? Now they'll put some enzymes, they'll put some polymer, but the name Surf remains as such. Same with Crocin. You go to the shop and you say, give me Crocin. Are you buying Crocin? You're actually buying paracetamol. But now it's become like Crocin means paracetamol, paracetamol means Crocin, right? Now it is Dola. Over COVID, you said, oh, I want Dola. So you imagine, so what we need to hear and listen and see is I don't have to only protect patents, but I also need to get a huge trademark. And as I said, we file lakhs of trademark applications in India as compared to our patents. And there's a huge number, 80% of all the trademarks filed are actually from Indians. And therefore, don't only think about patents, but there are many other IP protection, and every product or a process, you could have different types of patents or different types of IP. Copyright, you do write manuals, you write papers, you may want to paint, everything can be protected by copyright. And of course, patent is how it works. So in the, what I call as, there are 3 important criteria. I could say 4, but let me go for 3 for you to get a patent. So patent is for an invention. It is for an idea which will then be used, and therefore you protect it. We protect the invention which is based on an idea, and therefore it has to be new, inventive, and it has to be useful. Also, the person who goes and files it first gets the patent. It is not, if you delay and you file it later, you may not get a patent. So it's important for me to conceive the ideas, to start working on it, but also be very fast in going and filing it. And therefore, this is a very important question. When do I go and file it? Can I file it at the idea stage? Or do I really need to finish my innovation and invention and then file it? I would say it's in between. We don't ask, or we don't recommend that you file a patent when it is in the idea stage. Because many times there's also called an enablement. You need to show how you did it. In the US, they call it as reduction to practice and so on. So when you are nearly ready, you get 1 year time to improve on it. And therefore, when you know it will work, this idea will work, you know you can show that it works, and then you go and file a patent on it. And as you're improving, you can file more patents and then merge all of them and then file a final patent as well. So these are the 3 things that you need to be do, and everything, it is legally based, it's a law-based protection, and therefore if you file in India, you get protection only in India. And therefore, if you know where your market is, if your market is Malaysia, if your market is Europe, if your market is Singapore, decide and see where your market is. And based on your market, you need to go and file in all these countries. So it's also important. And of course, your TTOs and others will help you to understand where it is. Also, there are common myths that simple innovations are not patentable, which is incorrect. And why do I say that? I say that because everybody knows, about Post-it. Post-it was nothing else but a failed invention. Why was it a failed invention? Because the inventors were trying to get a glue which will stick and not come off, correct? I need a very good glue for it to stick and fix itself. But every time they would do it, and this would come off. And they said, this is a bad glue. But suddenly one of the inventors or nearby said, oh, that's a great invention. Why don't we come up with Post-it? And see the value of Post-it now. And they said, great invention, I stick it and I can take it off. I can stick it and I can take it off. And so now, not only the 3M got 3M. I mean, when you say Post-it, you think of 3M. But 3M is a company, right? But Post-it, it has become like Xerox machine. You know, I want a Post-it. And therefore, a failed invention can also be a great invention. And so this is why there's nothing like a worldwide patent. You need to go to every country, wherever you think there's value for you. And software implemented inventions, people say it's not patentable. It is, but you need to show a technical effect to that. So when I say novelty, inventive step, and industrial application, I'm going to come to that. A novelty means it has to be new. And an inventive step means it should have a technical advancement over whatever is the in the prior art, in the existing knowledge, or it can have an economic significance or both. And the last about utility is it should be capable of being made in the industry. Utility doesn't mean that I have to actually sell that product out, but an intermediate, or something that I can do, can be anything that can be made or used in an industry is also thing. I'm just going to talk, a lot of the times I have questions on novelty and novelty inventive step. Just for the sake of explaining this, what is novelty? And I call these as the all element rule. Why? Your invention is based on the claims. So a patent application is a techno-legal document. What do I mean by that? It's a lot of technology, but it also has a legal space to it, and the legal part really comes in the claim. So let's look at my claim. I have a claim of 4 components, A, B, C, D. When is it novelty is destroyed? When do I say it's not novel? When do I say it's not new? Is I can show any prior art reference. I can show any internet search and show that one document has all the 4 elements A, B, C, D. If there's a single prior art and showing me all my components of my invention, then I say that you have no novelty and that it is an anticipatory document. So it can be for a product, you see what are your elements. If it's a process, then you look at what your process steps are. If it's a combination of A plus B, then I must have a document which shows that. And it can't be mosaicing. I can't show in my prior art A somewhere, B somewhere, or you can link it. It should be able to show the person, yes, this document does show that it has all the elements A, B, C, D, and these are the claim limitations. I may have had E and F outside, but my claim says that I need to have these 4 elements, A, B, C, D. Now, when I say 4 elements, it can be components in a product, or it can be A, B, C, D can be the 4 steps, or A, B, C, D can be a combination of 4 drugs, or so and so forth. And therefore, it's very important that even when the patent office gives, or you say, or you do a search, is there any prior art which shows all the components of your innovation, which is A, B, C, D. And this is very important because novelty is a very, very legal, and therefore you need to be sure what do I mean by that. Now, if I look at this chair, and of course from whiteboard that I took, every chair is different, right? Everything is a chair. But each chair is different. It is novel. Okay? Now, why do I say that? I had a chair 1 which has 4 legs, it has a seat, it has a backrest. Great, that's a chair. But I look at chair number 2, I say that is novel. Why? It may have all the 4, but why do I say it is novel? Because it is a rocking chair, correct? And for every innovation, when I want to file a patent, most patent attorneys will ask, what is the problem and what is the solution to that problem. You don't just come with a problem, but you need to also give a solution to the problem. And so if I look at chair number 2, the grandmother wanted a rocking chair. My first chair will not rock. Therefore, my rocking chair will be novel as compared to this. Of course, freedom to operate is very different. So let me not talk about freedom to operate. And therefore, every chair that you see, you need to tell me why. I mean, chair is already known. Why are you coming with chair number 2? Why are you coming with chair number 4? Chair number 4, it's easy. I can fold it. I don't have space in my house. Chair number 7, it has wheels. Wheels were known. Chair was known. But one smart Alec came and said, oh, I put wheel to a chair. Okay? Or wheels to a luggage. Earlier on, we never had luggages, didn't have wheels. And the coolies had to carry it. But then they said, oh, wheels are known, luggage is known. I have come as smart Alec and I have put the wheels to a chair or the wheels to a luggage. Okay? So these are simple innovations. They'll say, oh, wheel was known, luggage was known. So what is so great about it? But I've come with a problem and I've solved the problem. And therefore, every time that you think of an innovation, think of it, what is the problem in the art and what is my invention going to solve? If you do that, you will be very, very clear on that. Another concept called as genus and species. I don't want to go too much into this, but I'll just give a little example. Okay, let me give you. A genus is, let's say I have a component. One of the component is oil. I have said A, B, C, D, out of which D is oil, the other 3 are something else. So I've claimed a genus, that is A, B, C, D, where D is oil, just oil I'm saying. And then I look at a prior art, and I'm seeing whether there is anything which talks about the different types of oil or not. Now, I have found a prior art which says I can use coconut oil. I have a cosmetic product. I have A, B, C, D, and they have put coconut oil. Now, I have come and said, no, I'm not using coconut oil, I'm using oil, any oil. Now, this is a big concept, it's a very legal concept, that if there is a prior art which says that I can use oil in a cosmetic product, it will destroy the novelty of the larger one, which is oil, okay? So, a species, a prior art, which talks about a specific component, like coconut oil, can destroy the novelty of a larger genus, which is called oil. But is the reverse true? I went and filed a patent and I said oil. I have a cosmetic product, A, B, C, D, D is oil. Somebody else comes in and says, oh, look, I have used olive oil. And will he get a patent? Yes. So a genus never destroys the novelty of a species. It's a very, very difficult concept because they said yours is a genus, you have not shown it with olive oil, but when I use olive oil, I can get better properties, it's an improvement over what you are having problem. You did not talk about it in olive oil, you just said oil. You may have said coconut oil, but I can show olive oil is better than coconut oil, and I can get a patent. So these are called as improvement patents, and therefore a species will destroy the novelty of a genus. A genus never destroys the novelty of a species. Now, whether you will get a patent or not, whether it has inventive step, whether it's useful or not, that's a different part. I'm just talking about the concept of novelty that I'm talking about. This is again, there are a lot of alternatives. So your citation, if my citation talks about a species and my claim is an invention, then it is a bar to novelty. I mean, this can really be a problem to hit. But if I have a genus like an oil, my claimed invention is a species, I can still get over the novelty. Alternatives. So you have different alternatives of polymer, different alternatives of oils, then you can have, you will have problems of novelty. Alternatives in form or de facto is also a problem. I now go to the concept of inventive step. We said, okay, novelty, very clear. One prior art must show A, B, C, D. But what happens in inventive step? In inventive step, I have two prior arts or two documents. One document, my invention has A, B, C, D. I have one prior art which talks about A, B, C, and I have another invention which talks about D only. Now the controller, the examiners will say, oh, no, you have passed the test of novelty because there's no prior art which says one document with A, B, C, D, but there are two documents, one talks of A, B, C, the other talks of D, and therefore I would combine. Therefore, a person skilled in the art can combine these two documents to come up with an invention. Therefore, you need to show how by combining. Was it obvious for a person to combine this? Was it in the same field? So let me take, I have a molecule which is in the paint industry, and I take it and I put it in the cosmetic industry. Then it may not be a person obvious to skilled in the art. Sometimes USPTO says it doesn't matter which art it is, but we call this as non-analogous art. And therefore, was it a person skilled in the art? In the cosmetic industry, would he go and look at what is happening in the paint industry or in the polymer industry? And therefore, it is very important, would a person skilled in the art be in a position to combine these two documents, the red document and the blue document, to come up with an invention which is got A, B, C, D. So it's a very, very subjective. It's how well you write your patent application. You should be able to show technical advancement. You should be able to show, yes, by combining all these, I come up with a better innovation. This was not taught, and so on. So it can either be a technical advancement, or it can be significant, economically significant. By combining D, which is much cheaper, I got a better innovation, or it can be because of both. And here also there's a problem solution approach. Because of adding D to this, I get a better result, and so on. So just to give you an example, let me say I have A plus B plus C as my invention, and there are prior art. The middle column is your prior art. If suppose my technology is only A plus B, I have a prior art which is A plus B, straight the examiner or controller will say it's not novel. There's already a document A plus B. But I have a technology which has A plus B plus C. I have a document which has only A plus B. I have novelty for my invention because the document doesn't show C as one of the components, and I pass the novelty. But A plus B plus C may not pass the inventive step, because I found that is A plus B plus C prime is an invention, and C prime may be equal to C, or there is C or C prime in another document, and therefore it is not inventive. So you will have to do this analysis. It's a subjective analysis, but just to tell you how these things work. So there is a test for invention, and you need to test what this invention is all about. And I always give this example, being a biotechnologist, always talk about Cohen-Boyer innovations, which actually changed the whole space in biochemistry, biotechnology. Definitely the earlier one was this Diamond versus Chakrabarti. I don't know how many of you all know about Ananda Chakrabarti's fight in the Supreme Court. How many of you all know about that? Okay, would you all like me to talk about that? Yes or no? Yes, okay. So there was this famous scientist, Ananda Chakrabarti. He just passed away recently. He's a great scientist working in the United States, and he came up with an innovation, a Pseudomonas, where he modified Pseudomonas, not by genetic engineering methods, but by recombination methods. And he came up with a modified Pseudomonas. Now, when this modified Pseudomonas was put, it can clean up the oil spills, which is the fossil fuels, fossil oils, correct? And he could. So it was great invention. It was prior to 1980, sometime in 1976. Everybody talked about it. But the USPTO said, sorry, I am not going to grant you this patent for a modified Pseudomonas. So what had he had claims modified Pseudomonas. He had a method of cleaning up the oil spill by putting this Pseudomonas, correct? One of the claims that they objected to, they gave him the method. You can go and use the method and so on. But I will not give you, USPTO said, this was prior to 1980, and said, I'm not going to grant you a patent because this is a living organism, Pseudomonas, you've modified it, it's great, it is not discovery, but we cannot give patents for something which is living. Okay, this is prior to 1980. He went all up to the Supreme Court in the US, and there is this Diamond versus Chakraborty case, which is a classical case that everybody doing IPR should actually look at it and read about it. And the US Supreme Court came and said, nothing in the US PTO law or the US law which stops or inhibits any inventor from filing for a patent for a living organism. And they said this thing, any invention carried out by man using the hand of man, under the sun, using the hand of man. So two things, under the sun, any invention under the sun using the hand of man is patentable subject matter in the US, all right? Any invention under the sun using the hand of man is patentable subject matter, and therefore he modified Pseudomonas, and therefore he can get a patent for it. So 1980 was the year that he fought and got this patent allowed, and the USPTO had to allow that patent. So it was also always, these are legal arguments. What you do in science is fact-based, but what you do in law depends on what the legal writing is, what is legal thing that can happen. And that changed. So Diamond versus Chakraborty is a famous case in the United States, which changed that living organisms can also be patentable subject matter. And then came Cohen-Boyer, where there were two Stanford scientists, and they said, great, we are now making a modification. We take a plasmid from E. coli, which is a microbe, and we've added the insulin gene into it, which is human insulin. So what was the problem? Earlier, before this Cohen-Boyer, if people were diabetic, they were giving insulin. But where was the insulin coming from? It was coming from animals like calf, sheep, and so on. And you had to kill it, take the pancreas, isolate the insulin, and give it to people. So what was the problem he solved? He said, I don't have to go and kill animals. I don't have to take this pancreas, take the insulin, which is very similar to ours, but I would now make human insulin in a fermenter, in a petri dish, or in a fermenter, in a flask, and I can now produce tons of insulin. That changed the whole scenario. And therefore I say this is the second one in biotechnology, Cohen-Boyer, where it changed the whole thing, that I now can produce any human gene, any human protein. I can express any of these in a fermenter, in an E. coli or yeast, and so on. And this brought about huge amount of royalty. They went and filed a patent application in 1980. They got their patents, and for 20 years, up to 2000, they made tons of money, and around more than $500 to $600 million. University of Stanford got royalty. Royalty alone was in the tons of about 500 or 600, I don't remember the exact thing, but that was just the royalty. That also gave the birth to a lot of biotech industry. So one patent application, a couple of them, and you get royalty for University of Stanford, and also birth of many biotech companies like Genentech, Amgen, you can name it today, Roche, all of them saw a value in this, and tons of growth hormones, erythropoietin, name it, they were all made use this technology, which is recombinant DNA technology, and now we studied it in textbooks, school children study it. The value of patenting is very important. If they had not patented their invention, that much amount of money, that is 500 million, would not Stanford would not have got, of course, they also got huge amount of money. The birth of the whole industry would not have taken place. Why do I say that? Because Taxol was a molecule invented by an Indian scientist, but he didn't patent it. No company was ready to come and put their money because they said, there's no patent, there's no monopoly, why will I spend money on commercializing Taxol? Right? I don't want to. They then made some other things. Government of US come and said, no, it's an important molecule. We'll protect you. If you spend money in clinical trials, we protect you and so on. And therefore, the value of patent is you get a monopoly. A lot of companies will come to you. Venture capital funds will come to you. And you can see that you can make a huge amount of revenue based on your patented technology. Another very important thing is hybridoma technology, which you can produce antibodies using hybridoma technology. These were Cambridge scientists. They had an NRDC like what we have. They went to their tech transfer office and said, I have a great invention. I have hybridomas and it can produce antibodies. I don't have to go to an animal. Like today, if you want to produce antibody against snake venom, you will go and inject a horse. Then after 6 weeks, 8 weeks, you will remove the blood, serum, again isolate this. I don't have to do that. I can produce the antibody in a cell. It could be a eukaryotic cell. It's a great invention. The TT officers laughed and said, you're a madcap. You go home. How can it ever happen like that? We are not going to patent this invention. And they didn't fight. Therefore, hybridoma, the Cambridge University lost money because it was not patented and they could not get revenue from it. And the inventors lost. Therefore, what I'm trying to say is, you need to understand, you need to convince your TT office to say, yes, this is a great invention, and I need to protect it. And how well you protect it, of course, you fence it and so on. So what I'm trying to say is, it is up to you as a scientist, as a researcher, to actually believe in your invention and get through. I also say during COVID, we saw my labs and a lot of companies, including IIT, IIT Delhi coming up with innovations to test for COVID that can also be protected. The kits can be protected and so on. It can either be PCR, it can be by ELISA, it can be by RT-PCR and so on. It can also be different methods. So for the same technology, for the same detection, you can have different methods like RT-PCR, ELISA, and so on. You could have different sensors, you could have different primers, and you can do the detection. Any questions? Anybody has any questions? Yes.
I will go for my innovations, look through in the citations, and I can see A, B, and plus C. So if A, B, C has any change in the formulation amount, will that make it novel as well? Like when C is equivalent to C dash,
yeah,
and we just have the, quantity difference. So
yeah,
will that make it novel?
So there are, it's a very good question. So this is a very, very good question. So it's like a genus to a species. I put A, B, C. I did not give the quantity, what proportion A plus B plus C. But now I come up, A plus B is okay, but C I change, correct? Now in India, we may not get. Because India says, once you've got A plus B plus C, then you may not get. We could try, but it would be difficult. But in US, all dosages, you can get a patent for it. Okay? What are the great examples? Anybody knows about semaglutide? What is semaglutide for? GLP-1? Agonist? Yeah. So we go V, Ozempic, and so on, right? And it's only the dosage difference, correct? And so bevacizumab is another example where I can get just by dosage differences or a formulation. Active ingredient still remains as bevacizumab. But now I change the formulation, I change the composition, active ingredient remains the same, It can be slow release, it can be another way, and so on, and the amount, and I can change it. It can be from cancer, it can be from eye. Let me give you a new example, which is very, very thriving, is pembrolizumab. Okay? That's again another antibody against PD-L1, PD-1, and it's called Keytruda. But it's a fantastic drug. And if you go and look at the patent, this original patent is for the antibody 6 CDRs, pembrolizumab, great. But now you see follow-on patents which are for different uses. One could be for lung cancer, NSLC, one can be for brain, it can be for head and neck, it can be for any others or other indications, right? So as they go and do this, you can get in the US, but in India, to go and get for new uses of a known molecule will be difficult. For different dosage forms will be difficult. Because India wants to sort of protect and say, okay, you've given A, B, C or invention, it doesn't matter whether you change the dosage forms. And so you have to be careful and clear that whether you want to go and protect it, whether you want to do it, and so on. Okay? Yeah, any other? Yes.
In that case, is it worth to actually mention in your drafting itself a wide range of formulations, starting from a very low range to a high range in your draft itself, so that you get a patent already in India?
Yeah, so I would say yes and no. You may give a range, correct? You may give a range. But tomorrow the controller will come and say, you're just writing these ranges, show me the exact enablement, correct? He'll come, here, there he is. He'll say, sorry, I'm not going to give you, because just like her things, so A, B, C is there, but unless and until this range is such a thing that because this range change or this change, you're getting a synergistic effect or something different or technical advancement I can do. We as attorneys, we try, but we're also careful. We'll tell you no. Controllers and examiners will not give you because you've not enabled it. You've enabled one composition, I will give you that. I'm not going to give you everything under the sun for this composition. And I would also not tell you to do that because you don't only think about India market, but I want to think of it as worldwide garden. Okay? And so if I now put everything in my patent here, what am I going to do for follow-on? What am I going to do for improvement? So if you just take pembrolizumab, there may be hundreds of patents, correct? So I always tell this to people, whether you take anti-PCSK9 or any of the antibodies, they are very, AbbVie is a famous example where they could had tons of patent applications for one molecule, right? And therefore, I would be careful. In India, if one combination is known, I don't think they will give you for different dosage forms. You can't get unless and until you're super, very good. Any other questions? Extremely good question. So that's what I'm going to do now. Let's think of different things. Size of the particle, correct? We all know now urea. Can anybody know about nano-urea? How many of people have heard about nano-urea? Correct? Great. Patent office has granted patents on that. Urea is well known as a fertilizer. Correct? And farmers use it. India subsidizes urea. But then they came up, Terry and IFCO, came up with an invention called nano-urea, where with this nano particle, nano-urea, I see that it can be absorbed better. You need to put lesser amount, and therefore I get a better result. Therefore, a nano-urea is also patentable. Nano is known, urea is known, but I was the first person to come up and make it as a nano-urea. And therefore, you can get a patent on that. So there are patents for nano-urea, nano-phosphorus, nano this, and so on. You can get also slow release. I have a molecule like sitagliptin, but now I come with a slow release, like metformin, you get a slow release, a sustained release, because I want to have it for a longer period. What is the problem? I have to take 3 times medicine. But if I have a slow release drug, I have to take it once a day. So that's a problem. So always think of it, just like you also, Dr. Kunu, what is the problem and what should I do about it? And therefore, nanourea can get. And I always tell people mRNA was there for vaccines, but the invention was in that LNPs, which is again a nanoparticle, lipid nanoparticle, because how do you deliver these mRNAs and deliver? So you can get a patent only for these LNPs or nano and as it is. And when I write there, I'll try to write it broad so that others don't copy it. And then you do follow-on patents and cover for other things as well. Okay, any other questions?
Yes, ma'am, please.
Yes.
Suppose I have developed equipment that has 4 claims, and there is no document that actually comprised all these 4
Components.
Claims. But 4 different documents are there. Those separately they accomplish these claims.
Yeah.
Does it patentable?
So see, you've answered your question yourself. I have component 4 things, correct? And there is no document which shows all the 4, right? Am I clear? So you've passed the novelty. I think if there was 4 documents for your invention, the lesser the chance that the patent office should give you an lack of inventive step objection. You should be able to get through. Why do I say that? There are many case laws. I have one prior art which shows ABC, correct? And I have one document which shows D. So it is easy for me to combine A plus B plus C is already known, to combine one document or one molecule from this document and say ABCD, correct? It's easier. But if I have to combine A from here, B from here, C from here, and D from there, it is not possible for a person skilled in the art. And there are many, many case laws in India, US, everywhere. The larger the number, the bigger the number of prior arts for inventive step, then it is easy for us to get over the inventive step or the non-obviousness, because it's very difficult for a person skilled in the art to combine 4 different documents, the teachings from those 4 different documents to come to the invention. Second thing is a motivation for me to combine. Why do I say that? If I have a document A plus B plus C and I have only one document D, there must be a goal post. Why would I take that document? Was there a goal post? Was there a motivation for me to combine D into A plus B plus C? So we have to be, as researchers, have to argue and say, no, there was no motivation for me to combine D. Why not combine E? Why not combine F? I have been smart enough to combine D, and there was no motivation in D for me to combine with these 2. One, you say they're different areas, there was a different thing, what was the negative part about D, and so on. And you can also show some negative examples by combining, that document had D and E. But if I combine it with E, I don't get result. But they said with E, you get a better result. So there are different ways, but one thing is very important. For lack of inventive step, the more the documents that the controller gives you, the better chance for you to get over obviousness. Simple logic, correct? Very difficult for a person, okay, A, then I take B, then I take C, then I take D. Everywhere there must be a motivation, a goal post, correct? For me to go from here to my house, I need a goal post, I need a direction. We didn't have Google Maps at that time, but where is a direction for me to combine A plus B plus C plus D? And that should be your argument to go forward. Any other questions?
Hello, ma'am.
Yes. I don't know who is it.
हेलो यस मैम मॉर्निंग मैम मेरा क्वेश्चन ये है कोई सेम टेक्नोलॉजी सेम पेटेंट अभी आईपीओ में फाइल होता है वही बीपो में फाइल होता है
किसमें
बीपो
फाइल करते?
WIPO
WIPO.
तो इस इन दिस केस क्या होगा ऐसे में
सेम इन्वेंटर और डिफरेंट
हाँ
इन्वेंटर?
सेम इन्वेंटर नहीं सेम इन्वेंटर नहीं टेक्नोलॉजी सेम है
सेम इन्वेंटर सेम टेक्नोलॉजी, करेक्ट?
मैम इन्वेंटर सेम नहीं है बट टेक्नोलॉजी जैसे कोई टेक्नोलॉजी हमने इंडिया में फाइल की है
हाँ.
और वही सेम टेक्नोलॉजी यूएसए या बीपो में फाइल होती है
ठीक है.
तो इन दैट केस क्या होगा?
करेक्ट. वन इज इन दिस इज वेरी इंपॉर्टेंट. फर्स्ट आपको क्लेम देखना है. You have got ABCD, they have also filed for ABCD, okay? Who filed first? Who filed first? If you filed in India first, you get the priority, correct? So it's very important for us to file as early as possible to get the priority date. If there are two different groups filing the same thing at different locations or different jurisdictions, the person who has filed it first, this is the first to file principle. The person who filed it first gets the innovation, correct? Now the question is, did that person come into India? There are many reasons. Okay, the WIPO person filed it before, but he never came to India. Okay, and it is within the 18 months period because there was only this. We have something called 13(1)(b) in India section, which says, did they come and file in India? Was it the same invention? Did the claims map? If so, and if they didn't come, then you get a patent. But generally, it is a person who files first who will get the patent. Okay? But there are many ifs and buts, but this is what the general principle is. Any other question? How much time? Done. Yeah. Any other question, and then I'll stop. Yes. Yes. Extremely good. I'm just going to finish this question. I think you've really talked. One first question is, today there is something called Google patent. You go, press Google patent, you know how to search, you can search it. Next, there's something in Europe, EPO called SpaceNet, which I recommend very well. Then there is patent scope in WIPO. There is Indian Patent Office searches. So if you go to any of these things, Google Patents is free, SpaceNet is free, WIPO patent search is free. You just put that on the Google, it will take you to that place and you can do the search. How would you do the search? Like he said, ABC, you go and see whether all these are there or not. Okay, so it's just like how you do literature search. Am I clear? So that is there. But today, we are one step higher. If you do a Google search, it will tell you this, this, this. If I do a Perplexity search, and I say, can you find any document which has A plus B plus C? It will do. It will give you the citation, and you can go there. But you have to be very careful. Why do I say you have to be careful? Okay, if you go to Google Patents, you go to WIPO, or you go to SpaceNet, these are already filed applications, and you're sort of little protected. But if you put it on OpenAI, ChatGPT, or Claude, or you do Perplexity, you are exposing your invention to the server of these people. And therefore, they may use that. Tomorrow you have done A plus B plus C, he comes and says A plus B, says, no, it's already known. Because they're using that as a machine learning on and on and on. So be very careful. Wait a minute. Be very incognizant, it does not matter. Okay? It doesn't matter. He is also not telling who he is, somewhere he is. No. The minute I never use Perplexity or AI tools to do a patentability search. You are opening the Pandora box and you're opening your invention to the world. Just like you talk about your invention before you put it for publication, why would I go to OpenAI or ChatGPT or Perplexity and ask for these? There are some closed things like search tools for patentability. They're expensive. You can use it. IP Rally, there are a lot of those things that you can use. But please be very careful about going and using an AI tool to do your searches. Okay. I think with this I will stop.
Thank you, ma'am, for an excellent start to the day. And your clarity and guidance have set a strong foundation for all of us, for all the discussions that will follow ahead. Now I would like to invite Dr. Namita, Vice President FITT IIT Delhi, to come on stage and present a token of appreciation to Dr. Malati.
Thank you very much. Thank you very much. Thanks everyone.
There's just a small announcement for the participants. So at the end of the workshop, we'll be sharing a QR code with all of you, and wherein you can put in your details, and we'll be providing e-certificates for participation at the end. Thank you.
Next speaker is a senior IP expert with over 20 years of experience in patent examination across pharmaceuticals, chemistry, and traditional knowledge. Currently, he is in charge of India's PCT receiving office and oversees international patent filings. He has represented India at key WIPO meetings. He has also led nationwide IP awareness initiatives under NIPAM, conducting workshops across the country for students, startups, and industries. Please join me in welcoming Dr. Rohit Rathore, Deputy Controller, Indian Patent Office, Delhi, who will speak on strengthening India's patent system opportunities for academia, startups, and industries.
Good afternoon, everyone. Madam has already covered a lot of technical part, even formal part. So rather than starting with the presentation, what I will do, I will go to my website and just let you know certain facilities which were provided to the applicants. So I just want to know if anyone has already granted patents or something like that. Okay. So this is our website. I'm just showing it because technical part is covered by Madam, and even Mr. Pandey will be covering that, most of the patent drafting and case laws. So I just want to focus on the aspects that what type of support IP office is giving. So primarily all the services are provided here on our IP website. And if you see here, as somebody has asked about patent search also. So here you can see there is an option of public search. And in this, you can do search for patent, trademark, design, and even register of patent agents and patent register is also there. So you can search everything. Along with that, the additional feature which is here, which I have seen that many people doesn't know about it, is the status of the patents. So clicking on this particular link, by giving your application number, you can get the status of your application. And of course, it will come only after the publication of your application. And you can see it's a real-time upgradation of this. For example, suppose I have issued FER, immediately it will be updated here. So you can cross-check your application status from this website, because we received a lot of inquiries, and sometimes if suppose agent is not available, so we get queries how to get the details from application. So you always can get this details from here. So everything from the issuing of our office, every communication which we are filing, which we are sending, you can see it here. Whatever the communications you are sending to the office, you can see here. And beside that, if any hearing is given, you can see the hearing dates, and everything is provided in this particular website. And here you can see the controller decision. So you can also download the decisions given by the controller. And here is the cause list. These lists basically refer to the, if hearing is given in your case, so you can click on this particular link for patent I am showing. And it is for every IP, trademark, and copyright also. So here you can see the hearings which were scheduled for today, and the mode. So link is, so you can get the link from your agent, or if you have, because we are right now since long time we are a paperless office. Everything is done online. So on our desk, this is USP of our office, we will not see a single paper on our desk, because we are whole process of examination up to grant is online, and every section is dealing the files online only. So this is with respect to this particular feature. So here you can see from the and this is e-filing. So on a single page, you can see that you can file your application by clicking on the e-filing patents. Then you can, before that, you can search your patent, because of course you need to do a prior art search. So you can search your patent you can search your invention. Thereafter, you can file. Then you can check the status. If hearing is there, you can attend the hearing, or you can see the link for that. And thereafter, of course, if some decision is there, that also you can access here. And once it's granted, patent register is also available. So you can see the status of the your patent, whether it is alive or not, because you need to pay annual fees, renewal fees every year after the grant of the patent. So this particular aspect I just want to show here. Another thing, if you see, though I have to talk about patents, because when I'm going through this particular website, you can see patent, design, trademark, GI, and copyright, and SICLD here. All these IPs, whole detail is provided under these drop downs. So you can see everything here. You can do the searches. You can file. You can find any information, FAQs, or whatever is required is available here. Another particular aspect here is manuals and guidelines. So on this page, you can see whatever the acts, whatever the rules, current rules and manuals that how office works, or basis for the examinations. Then we have different guidelines, and if you click on it, you can see that recently guidelines for examination of Ayush-related invention, basically that means traditional knowledge-based inventions, was released. Then you have computer CRI guidelines, then you have biotechnology guidelines. So while drafting your application, or while thinking of getting patent, you can first just go through these guidelines, so you will get an idea what type of patent can be granted in India, of course. And so this is all the resources that is available to you. And as Malti Madam has already said, I also emphasize this. We specifically academia field, people think that research field, that publication is the biggest source of knowledge. But I think that patent databases, these are freely available databases, which are minimal used by any of the researcher, and it contains more information than research papers, because research paper will be talking about the specific case where you have succeeded. But when you're drafting a patent, you will be covering a lot of other aspects also, which will not be covered in that, which may not have been covered in that particular scientific paper. And beside that, these are freely available knowledge to you at your doorstep. You have to simply click it. You can go search in INPAS, which is our database, or European Google Patents. So please use it. That's my advice from Patent Office side. And now coming to my presentation. So it is about strengthening India's patent system, opportunities for academia, startup industry. So patents, you already know by now what is patent, so I will not go much in detail. I will simply say that what's its role. So you can better tell me that what's the role, that it encourages R&D invention, protects inventions, and enables commercialization. And as far as the relevance for India is concerned, of course, for any country, the IP ecosystem plays a very important role. And once we are moving on the innovation ladder, a robust patent system is a key, or you can say is a driving mode to get that rise in the, as far as economy is concerned, or in general status of the country is concerned. Patent criteria, Madam has already touched upon. So now legal framework, the Patent Act basically is administered by Office of Controller General of Patent Designs. So and there is a Patent Act 1970 and patent rules, using which we do the examinations and all the processing is done. There is a summary of patent examination process. Basically, you have suppose already filed the patent application. So what our office will do the examination. There are two types of things which we cross-check: formal examination and technical examination. When I say formal examination, we see whether forms are there, proper forms filing is there, fees is there, whether you file your application or other documents within time limit. So these are the formal examination. And as far as substantive examination or technical examination is there, which is analysis of novelty, innovative step, and industrial applicability, and Section 3. Section 3, I think Mr. Pandey will be discussing because I think Madam cover nahi kar payi that part. So Section 3 are certain inventions which are not patentable in India. For example, method of treatment, and there's a long list of such inventions which though may be novel or inventive, but they are not patentable in India. So once we complete the examination, we issue a first examination report, which is in common usage we usually say FER, and it contains the gist of objections. At what are the objections? Suppose your invention lacks novelty, we will send you that particular communication objection that your invention lacks novelty, and we will send you the details of the prior art due to which that particular objection has been raised. If there is any objection under Section 3, we will raise that. If there is any issue, somebody has asked that I want to that you have a broad claim, but support is not there. So we may raise the objection that sufficiency of disclosure is not there, and if biological material is there, so you need to provide the details of deposition of the biological material. If that is not there, that type of objection you can receive. Besides that, if claims are not properly drafted, there is not definitive or some vague terms are there, so those will also be referred in this particular examination report. So first thing that you need to do, be it office or be it agents, madam or Pandeyji, they will always advise that please give the reply to the examination report at the earliest. Though time is there of 6 months, but don't wait for the last moment. Try to file it as early as possible because it helps office and also helps you, because suppose if still some objections are there, office can communicate to again. Otherwise, if you're filing it too late, office may directly give you hearing. Though hearing is, a lot of people have some negative connotation with the hearing, but I personally advise that hearing is not something you should be feared of. You should feel happy if you're getting a hearing, because you are now getting a chance to directly communicate with the controller. Usually it's only correspondence. It's like कि भाई आप WhatsApp पे chatting चल रही थी अभी तक. Now you are able to do a video call. So you will be available, controller will be available to you. So it's a very good opportunity for you to present your invention or present your views. And beside that, I think a lot of agents also suggest, and we also suggest many times, if you think that you can represent or you can give reply of certain aspects better, then you should also appear for the hearing. In my personal hearings, when I was in examination, I have always suggested that please bring the inventors, because many times inventors can highlight certain aspects which we as a controller or even agents may miss. So we always advise that you should attend the hearing. Now with VC facility available, you can attend it at from your home or from your office. Only condition is please inform the office before attending that we will be attending. So accordingly, the controller will let you know whether you can attend or not, but please attend if you can attend it. So once you file the reply, we will again re-examine. Suppose there is a lot of amendments are there, so there is a possibility that new citations may be raised again. And suppose if certain restrictions are there, so your application will go for grant. But still, if some objections is there, we will issue a hearing notice. We will give you a hearing. And after hearing, based on your submissions, which need to be done within 15 days of the hearing, and your arguments during the hearing, your case will be either granted or refused. And suppose it is refused, and then you can have remedy of challenging it or in High Court, or you can also appeal for the review of the decision of the controller to the concerned controller. Now, in general, there is a process that when you file the application, publication takes place. It's a worldwide phenomena. After 18 months, publication is there. So that means till 18 months, your application will be kept pending in every office. So to expedite the patent examination process, our office has this particular procedure of early publication and expedite examination. When I say early publication, usually, as I have told you, the publication take place after 18 months. But by filing Form 9, you can get the publication within 1 month from the filing of your Form 9. Second is expedite examination. You can file the request for expedite examination. Therein what happened, that your application need to be, will be taken on priority and will be granted in not less than 6 months, because there is a provision in our act which says that pre-grant opposition, which states that any application cannot be granted before 6 months. So even from this 6 months are calculated from the date of publication. So even if you have filed the early publication, your application is published, and it might be possible that all the objections have been met within a month, but we will wait. Still, we will wait for 5 more months to if somebody want to file pre-grant opposition, they can file. So we wait for the pre-grant opposition. After 6 months only, you can get the patent. So you can say at least 6.5 or 7 months is the minimum time in which you can get a patent by following this particular route, that is by filing Form 9 and expedite request for examination. Other advice, in general, if you are going through, you have not filed request for you have not filed expedite request, you have filed simple request, then in that case, to expedite the normal procedure, please file early responses of official communications, and of course, which I already talked about, attend hearings. It really helps. It is my personal experience that it really helps. It helps the controller because we are there to grant the patent only. Only thing which we need to segregate that which part can be granted and which part cannot be granted. So I think inventor is the best person to let us know, to basically, कैसे कहते हैं ना, you say in Hindi कि भाई प्रकाश डाल सकता है, रोशनी डालना कि भाई सर ये है actually मेरा patent, इस पे चाहिए. क्योंकि कई बार होता है, many times we have seen sometimes applicant emphasize कि नहीं आप broad लीजिए. Agent समझा रहा है, कई बार हमने भी देखा है. Sometimes reverse also happen. And so in that scenario, when the applicant comes, so many times it happens that certain things might not be communicated that properly in the hearing notice. That might happen because it's a technical issue. So sometimes while discussing during the hearing, the controller or the concerned officer who is taking the hearing may convey the actual thinking, what's going in his mind. कि this is the problem. मुझे ऐसा लगता है कि ये issues हैं और already prior art में हैं. तब आप बता सकते हैं कि नहीं सर आप जो कह रहे हैं ठीक है, लेकिन ये जो particular point है जो आप कह रहे हैं कि prior art में आता था, but my invention is more than that. My invention also has these features. Then we can many times advise कि okay, then do one thing, incorporate these features from further claims, of course the subsequent claims, and merge it in claim 1. Then you can have the patent. So it's a sort of discussion rather than a sort of court hearing or sort of just acting as a कि भाई हमें decision देना राजा की तरह नहीं. It's not like that. It's more like, because it's act, so I think the hearing word has been used, but it's more or less like a discussion. And of course, I will say something or controller will say something because एक और issue आता है, मैडम ने भी observe किया होगा lot of times when applicant or inventor attend the hearing, कि controller कुछ बोल नहीं रहा है, सर आप बताइए मिल जाएगा नहीं मिल जाएगा. It's very difficult to say at that stage. That point of time, usually what controller do, he tries to clarify the issues which are highlighted in the hearing notice or which he found during your arguments. तो एक डिस्कशन है वहाँ पे, हम आपको डिसीजन नहीं बताएंगे कि क्या होगा, बिकॉज इट विल बी बेस्ड फाइनली, सपोज सम जैसे मैडम ने कहा कि आप ब्रॉड ले सकते हैं या फिर ब्रॉड लेने में क्या इश्यूज़ हैं. जैसे सपोज कीजिए आपने एक पर्टिकुलर, यू हैव टेकन सम पर्टिकुलर क्लेम बट डाटा इज़ नॉट सफिशिएंट, you need to provide some certain additional data. So until unless आप ऑफिस को additional data दे देंगे, I can decide upon it that case. So I can only advise कि kindly provide the additional data. But that doesn't mean कि भाई कंट्रोलर ने कहा था additional data तो पेटेंट मिलेगा. It depends on the what type of data you're providing, how impactful it is. तो जो डाटा की जो क्वालिटी है उस पर डिपेंड करेगा कि मिलेगा कि नहीं मिलेगा. इट्स नॉट अबाउट क्वांटिटी कि भाई बहुत सारा डाटा दे दिया लेकिन आपने स्पेसिफिक पॉइंट क्लैरिफाई नहीं किया जिस पे कंट्रोलर ने पूछा था कुछ. सपोज कीजिए आई एम टॉकिंग अबाउट द एफिकेसी. ओके, तो यू नीड टू स्पेसिफिकली टॉक अबाउट द एफिकेसी. यू स्पेसिफिकली नीड टू टॉक. समटाइम्स व्हाट हैपेंस कि डाटा इज देयर बट यू आर नॉट एबल टू कोरिलेट इट इन योर स्पेसिफिकेशन विद द एफिकेसी और द स्पेसिफिक requirement of the act. So you need to correlate it, ki how this particular data means this particular thing. It means efficacy, that you need to correlate. So that thing can be done during the hearing. So please attend hearing if you can, or if you are able to explain it well to the agent, then well and good. But just cross check whatever the submissions are filed before and discuss it with your agent, and don't rush while filing the hearing submission, because the last point where you are going to submit something and thereafter your case will be decided. Now opposition mechanism, another thing that I always used to say, opposition as an applicant I always of fearful opposition, यार कोई opponent ना आ जाए, कोई opposition ना file कर दे. But if you see broader perspective, it's a very good thing किसी ने अपोजिशन फाइल कर दिया, मुझे मालूम है what mistake I did, मैंने prior art search अच्छे से नहीं किया. There are certain aspects which I already got which I should not have. So that opposition in a way is helping me also to exclude that part and take remaining part. क्योंकि opposition एक particular aspect पे आएगा. Another thing is from the viewpoint of opponent or even I will say applicant. Opponent word मुझे particular पसंद नहीं है, वो use होता है, लेकिन applicant. मैं एक applicant हूँ, जैसे somebody asks कि suppose same application has been filed in WIPO or same application has been filed in India. So as a opponent, suppose कीजिए मैं एक applicant था, I choose to first file in WIPO rather than filing in India. तो मैंने WIPO में पहले फाइल किया, in between बाद में किसी ने इंडिया में फाइल कर दिया, he filed the form 9, he got his examination expedited, I saw that particular application and now I can file the pre-grant opposition. कि भाई opposition मैं इसलिए फाइल कर रहा हूँ because ये already known application और already known technology है, if I am working on it or if I know of something. Because right now what we are doing, we are using the internet, we are using certain databases, but there are a lot of knowledge or there are a lot of aspects which industry person or a research or a academician may be knowing, which a controller examiner may not be able to search on the internet, because there is a restriction when we are searching on the internet or on the databases. Specifically with reference to TK, because I have worked on that, there are a lot of time we are getting certain, because the language which we are using is either English or Hindi. In lot of regional languages, there are a lot of literature available, which you can cite because you know about that. So that is the advantage of opposition. It's not just to oppose something, there's not, I personally don't think it is negative. Think in a that way, that person may be a party which is genuine. So there, he may file opposition to just to discourage you or just to, you can say, as a roadblock. But in general, what the reason we have imposed it, that whatever the patent office is granting should not be known. And as a public, as an applicant, as an accommodation startup, if you have anything which you can give information to office, you should provide that information. And second is post-grant opposition. And post-grant opposition is after grant of patent. And you can file that post-grant opposition within 1 year from the publication. Both the opposition starts from the publication of your first is publication of first filed application. Second is from publication of your granted patent. Both are published in our journal, and that journal is also accessible on our website IP India. You can see that journal. So this is the filing, because there is a very common question, sir, patent बहुत costly है, but India में costly नहीं है. E-filing अगर आप करते हैं, because E-filing में रेट कम है, फिजिकल फाइलिंग का ज़्यादा है, तो E-filing अगर आप करते हैं एज ए नेचुरल पर्सन, स्टार्टअप, स्मॉल एंटिटी, एजुकेशन क्वालिफिकेशन, दिस इज द कंप्लीट फीस 5600 मिनिमम जो आपको रिक्वायरमेंट है, इससे ज़्यादा आपको नहीं चाहिए. ऑफ कोर्स यू नीड टू पे, बाद में आपका जब पेटेंट ग्रांट हो जाता है, यू नीड टू पे दैट रिन्यूअल फीस 3rd year onwards, बट दिस इज द ओनली फीस. उसके अलावा इफ़ यू सम mistake is there, you have not filed something and you need to file the petition, that is an additional charge, but this is the minimum statutory fees which is required to get a patent. Okay, so you can see for natural person, startup, a small entity, education institution, fees is very less, but you need to be very careful. Don't go for fees. These are fees kam hai to khub sara file karo. It should not be like that. Go for quality patents also. Just don't keep filing for the sake of filing. So this is a general process that what applicant should keep in mind while filing the patent. You should please do prior art search. Jaise madam ne bhi kaha, we also advise do prior art search. Lot of patent databases are there. If you are not able to do, kindly take help of any patent agent or person who is well versed with the patent searching, because it will really help you in your patent prosecution, fast prosecution. Besides that, additional advice, I personally suggest that please incorporate, if you find certain important citations while doing the prior art, please incorporate as part of specification in the background art. Therein only you clarify what is the difference in your invention and that prior art, so it will help the office, and office may not raise that objection at a later stage because you have already clarified, you have already taken that particular prior art while drafting the specification. So we know the applicant knows about it, and applicant has also clarified the difference from prior art and invention. Then file the application. First to file, as madam has already told you that don't wait. Don't wait कि और अच्छा होगा. There is a provisional and complete. Use that, but first file it as soon as something you can. I will not say on your idea stage, but something has been come. You may be waiting for certain results, but if you have reached that this particular invention is going to work, then please file your invention as a provisional specification. Then publication will take place 18 months. Then you need to file request for examination. This is compulsory. It's just like जैसे आप कॉलेज में एडमिशन लेते हो तो एक एडमिशन फॉर्म जमा करते हैं, तो आपने एक एप्लीकेशन फॉर्म जमा किया, एग्जाम देने के लिए एग्जामिनेशन फॉर्म जमा करना है. In the same way, you need to file the request for examination. Then only the office will examine your application. Then of course FAR response होंगे, hearing है तो hearing attend करनी है, grant और refuse हो गया. Now don't sleep over it कि भाई grant होगा, now I'm happy. Please file the renewal fees. द रिन्यूअल फीस अगर आप फाइल नहीं करते, सपोज आपका पेटेंट ऑलरेडी ग्रांट था, आपने रिन्यूअल फीस फाइल नहीं किया, तो आपका पेटेंट लैप्स हो जाता है. इन केस द पेटेंट इज़ नॉट अलाइव, इट्स लैप्स्ड, एनी वन कैन यूज़ इट. यू कांट क्लेम एनी रॉयल्टी फॉर डेट बिकॉज आपका पेटेंट था. आज जैसे सपोज कि लैप्स हुआ तो वो लैप्स हो गया, तो फिर आगे कोई भी उसको यूज़ कर सकता है. प्लीज़ बी अपडेटेड अबाउट दिस एंड काइंडली चेक इट, पे द एनुअल फीस. एंड इफ़ यू थिंक because lot of things, though it's not our office prerogative, or we are not dealing with that part, but while licensing also many times we have seen that licensing कर देते हैं लोग उसी टाइम कि भाई मैं इतनी फीस पे नहीं कर पाऊंगा, तो डेट से कमर्शियल प्रॉब्लम रहता है कि भाई आप लाइसेंसिंग में लिख देंगे पेटेंट फीस आप देंगे, बिकॉज ऐसा कई बार होता है कि कौन फीस देगा. ऐसे केस एक दो हमने देखे हैं जहाँ इंडिविजुअल ने कहा तो कंपनी वेट करे कि आप फीस पे करेंगे, वो कह रहा है आप पे फीस करेंगे. तो क्लैरिटी रखिए फीस कौन पे करेगा, लाइसेंसिंग का कुछ टर्म्स एंड कंडीशंस में. नाउ coming to academia, startup and industry, this is not my idea. ChatGPT से लिया मैंने, to be very true, but I liked it. And academia produces knowledge, that's true, because academia में सब चालू होता है, and then startup convert ideas into products, and industry scales innovation globally. Recently, I am having some interaction with JPO, and therein I came to know about very interesting fact that JPO में startups and small entities has a very large number of patent application filing, huge number, because what they are doing, that industry have basically sort of, you can say, have outsourced all the small parts manufacturing and everything to these startups and small entities. So they are manufacturing small units for the big companies. Bigger companies are going for specific technique, know-how, knowledges. They are filing the patent. Rest of the patents are being filed for by the small entities, startups. And as far as academia is concerned, the problem, this is a general line, I will not go into it, because academia people are sitting in front of me, so I personally want to ask what are the problems that you face. As far as my observation is, people go for publication, not for patent. Please go for patent first, do the prior art search. These two things are very important. Any other problem which as academia you might be facing, you can tell. I'm just requesting, yes. Easier in the sense?
Sir, actually, I'm coming from a digital background.
Okay.
There is one term called API, Application Programming Interface. Now that Application Programming Interface, API, you can sort of interact with a digital body in a slightly easier manner. So I understand that the patent office has got that digitization in a very good way, but can the patent office go further with the help of NIC or with Digital India and enable the patent process to be accessible by API, which is a further programmatic interface, further digitalization? So just asking about digitalization of.
I'm basic chemist. I'm not, I don't have any knowledge. API मेरे लिए कुछ और ही है, pharmaceutical है. API is not goes for electronics. मेरे लिए API मैं pharmaceutical में चला जाऊँगा. अगर इन जनरल आप मैं बात करूँ, लेमन लैंग्वेज में बोलूँ तो डिजिटली आप फाइल कर सकते हैं हमारे एप्लीकेशन. देयर आर सर्टेन इश्यूज विद अवर फाइलिंग, मे बी देयर, वी हैव रिसीव्ड द फीडबैक्स, so we are working on that, and as far as information and filings is there, it's completely digital. You can access it and you can file it digitally. There is nothing, no physical document is required at any stage. And as far as you can say better user interface is concerned, we are also working on it and keep updating our module accordingly, be it our examination module on which officers are working or which the interface which public is using. So that thing is there exactly. I don't know if you have some specific suggestion, you can always send to our office, so we can look into that.
Sir?
Yes.
Sir, एक query है मेरी.
कहाँ से?
Sir, यहाँ से.
सर 2022 में मैंने अपना पहला पेटेंट अप्लाई किया था। मैं इंडिविजुअल नेचुरल पर्सन हूँ। तो 2022 में पेटेंट जब अप्लाई मैंने किया तो मुझे पता नहीं था कि अप्लाई करना है कैसे। तो काफ़ी सारे सोर्स मैंने सर्च किए इंटरनेट पर, काफ़ी सारे स्कैमर्स मिले, उन्होंने 1 लाख रुपये 60,000 रुपये इस तरह से मुझसे फ़ीस मांगी एंड वो फ़ीस मैंने पे नहीं की। फिर मैंने इंटरनेट पर सर्च किया पेटेंट के रिगार्डिंग, तो आईपी की वेबसाइट मिली, तो वहाँ से फिर मैंने हेल्पलाइन नंबर्स निकाले, आईपी के लैंडलाइन नंबर्स मिले। तो जितना सपोर्ट किसी ने नहीं किया उतना लैंडलाइन नंबर से मुझे सपोर्ट मिला आईपी की तरफ से। उन्होंने गाइड किया कि आपको कैसे कैसे फ़िल करना है, तो उनकी हेल्प से मैंने पेटेंट फ़िल कर दिया अपना और पब्लिकेशन भी मिल गया मेरे को। तो एजेंट मेरे साथ में नहीं है, मैं इंडिविजुअल हूँ। तो आगे मुझे क्या प्रॉब्लम फेस करनी पड़ सकती है और एजेंट का होना ज़रूरी है या नहीं?
देखिए, एजेंट का ज़रूरी है कि नहीं कहना बड़ा मुश्किल है। एक पर्टिकुलर स्टेज यहाँ पे एजेंट को होना बहुत ज़रूरी है, पेटेंट ड्राफ्टिंग, बिकॉज यू मे मिस सर्टेन थिंग्स। ओके, अगेन आपको लगता है कि आपका छोटा सा इन्वेंशन है, बहुत बड़ा नहीं है, आप ड्राफ्ट कर सकते हैं, यू कैन ड्राफ्ट इट वेल एंड गुड, बट इफ इट्स अ सॉर्ट ऑफ समटाइम्स सर्टेन टेक्नोलॉजीज कम इज सॉर्ट ऑफ यू कैन चेंज द पिक्चर, चेंज द सिनेरियो। अगर उस तरह कोई टेक्नोलॉजी कुछ एकदम नया काम है जो आपने पहले किसी ने नहीं किया है, तो वी विल ऑल्सो एडवाइस कि गो फॉर पेटेंट एजेंट। पेटेंट एजेंट रजिस्टर का लिंक है, लिस्ट है, यू कैन यूज डैट। आई विल नॉट से गूगल पेटेंट एजेंट। ओके, IP इंडिया पे जाके आप जाइए, वहाँ पे लिस्ट है। देयर इज़ वन स्कीम SIPP, आई विल टॉक अबाउट दैट ऑल्सो आफ्टर 2-3 स्लाइड्स। तो यूज दैट रिसोर्सेज। उसके बाद एक इशू आता है, आई विल नॉट से विद बिग कंपनीज, लेकिन इंडिविजुअल केसेस वी हैव ऑल्सो फाउंड वेयर पेटेंट एजेंट्स आर चार्जिंग इनॉर्मस फीस जस्ट टू गेट द फाइलिंग ऑफ वन डॉक्यूमेंट और समथिंग लाइक दैट। तो इन दैट सिनेरियो, इफ़ यू हैव ऑलरेडी फाइल्ड, इफ दे आर फॉर एग्जाम्पल रिन्यूअल फीस की बात है, तो रिन्यूअल फीस आप खुद भी फाइल कर सकते हैं। ओके, इट डज नॉट इंक्लूड इन दैट एनी टेक्निकल पार्ट। और जैसे मैंने कहा कि हियरिंग में आपको एक अपॉर्चुनिटी मिलती है, तो अब उस स्टेज पे एक अपॉर्चुनिटी मिलती है, आप हियरिंग को अटेंड करिए, लेकिन ये सब डिपेंड करता है टेक्निकल मैटर पे। तो हम भी पर्सनली एडवाइस कभी ये नहीं कहूँगा कि भाई सर ने कहा था बिना पेटेंट एजेंट के फाइल कर दो, कि आपका कुछ लॉस हो। वी डोंट वांट कि बाहर से एक पेटेंट आ रहा है मल्टीनेशनल कंपनी का, इतना वेल ड्राफ्टेड है, दे आर टेकिंग समथिंग विच इज़ फार मोर देन वॉट दे हैव वर्कड अपॉन। और हमारे यहाँ एक इन्वेंटर है, हमारे यहाँ एक इंडिविजुअल इन्वेंटर है जिसका काम ज़्यादा है, लेकिन वो उसको अच्छे से दिखा नहीं पाया स्पेसिफिकेशन। वी डोंट वांट दैट। सो यू हैव सर्टेन इशूज़ अबाउट द कॉस्ट, बिकॉज वहीं पे एक प्रॉब्लम आता है। पहली थिंग कि स्कैमर है, ओरिजिनल है, प्लीज़ सी द लिस्ट। वहाँ पे पेटेंट एजेंट्स की लिस्ट है, पेटेंट एजेंट की लिस्ट में आई थिंक डिटेल्स भी दे रखे हैं, आप उनसे कॉन्टैक्ट कीजिए, ईमेल आईडीज़ हैं, उनसे बात कीजिए। सेकेंडली, जैसा मार्केट में जाते हैं तो लॉट ऑफ एजेंट्स आर देयर, इट्स अ वेरी लॉन्ग लिस्ट। तो मार्केट सर्वे कीजिए, जो आपको ठीक लगा उससे बात कीजिए। एक पर्सनली हम भी एडवाइस करते हैं, हालांकि लॉट ऑफ यूनिवर्सिटीज़ में ये फैसिलिटी है, IP सेल्स हैं जो फैसिलिटेट करते हैं, बिकॉज दे नो कि भाई कौन कौन से एजेंट्स हैं, किस किस फील्ड्स के हैं। बिकॉज एक ये फील्ड भी बहुत इंपॉर्टेंट, जैसे मैडम बायोटेक्नोलॉजी की है, तो शी विल बी द बेस्ट पर्सन टू ड्राफ्ट द एप्लीकेशन फॉर बायोटेक्नोलॉजी। समबडी इज फ्रॉम इलेक्ट्रॉनिक्स, दैट पर्सन विल बी द बेस्ट पर्सन टू ड्राफ्ट फॉर द इलेक्ट्रॉनिक्स। कई बार स्पेसिफिकली द फील्ड जब इंटरडिसिप्लिनरी फील्ड्स होते हैं, तो उस केस में यू नीड टू वेरी केयरफुल वाइल ड्राफ्टिंग द एप्लीकेशंस। सो अगर नॉर्मल है, बहुत सिंपल है, आपको लगता है आप कर सकते हैं तो करिए। तरीका सीखने का ये है कि आप उससे पहले उसके पेटेंट पढ़िए। जब आप पेटेंट पढ़ते हैं तो आपको एक क्लेम का आइडिया लगता है। अगर आपको लगता है कि आप छोटा सा ही पेटेंट है, मेरे एक स्पेसिफिक प्रोसेस है जो मुझे वही चाहिए, आगे पीछे कुछ नहीं चाहिए, आई एम वेरी सेटिस्फाइड पर्सन, इतने से मैं खुश हूँ, तो यू कैन ड्राफ्ट इट। दैट्स नॉट प्रॉब्लम, कुछ नहीं है। मतलब ऐसा कोई लीगल स्टैट्यूटरी रिक्वायरमेंट नहीं है कि एजेंट ही इसको फाइल करेगा, एजेंट ही इसको ड्राफ्ट करेगा। Applicant or inventor can file it, applicant or inventor can draft it, they can go for the application, they can ask the office, they can communicate with the office, they can communicate with the controller कि सर मेरे केस का क्या स्टेटस भी आपको बताएंगे। एक और उसमें एक है, मैं दिखाना भूल गया हूँ, एक हम लोग के IPO हेल्प डेस्क है, आप उस पर अपने टिकट रेज कर सकते हैं अगर आपको स्टेटस का पता करना है, स्टेटस नहीं दिख रहा है या बहुत दिन से पेंडिंग है। देयर इज ओपन हाउस मीटिंग्स आर ऑल्सो देयर, पेटेंट के लिए आई थिंक वेडनेसडे को होती है 4:30 to 5:30, यू कैन अटेंड दैट लाइव। उसमें आई थिंक ऑल 4 चूज अटेंड दैट मीटिंग, तो आप अपना ग्रीवेंस पुटअप कर सकते हो। देयर आर लॉट ऑफ ग्रीवेंस रिड्रेसल मैकेनिज्म अगर कुछ ऐसा इशू आता है। जहाँ तक स्कैमर वगैरह की इसकी बात है, अगर आपको लगता है कि कोई एजेंट है, रिसेंटली देयर हैव बीन सर्टेन केसेस वेयर प्रोफेशनल ethics की जहाँ बात है, they have not followed that, so you can use that also, you can complain about that. But personally, I don't think there are very rare cases कि भाई जो listed agent है उसमें ऐसा issue आएगा। Scammers हैं तो of course scammer तो scammer ही हैं। तो be careful, use the website, use the list of the agents provided there. There is a list of facilitators also who can help you in drafting and everything. I will just come to that slide. It may help you more. You can better understand.
Sir, एक last query. एजेंट के साथ मैं फाइल करवा रहा हूँ तो जाहिर सी बात है अपना कॉन्सेप्ट भी बताऊंगा मैं उन्हें, तो उस टाइम पे सर क्या क्या सावधानी रखनी है?
कोई सावधानी नहीं रखनी है, रजिस्टर्ड पेटेंट यू नीड टू ट्रस्ट। डॉक्टर वकील पे ट्रस्ट करते हैं कि नहीं, वकील को बताते हैं कि नहीं? यू नीड टू ट्रस्ट, बिकॉज आप डिस्क्लोज नहीं करेंगे तो कैसे होगा? वन कांट ड्राफ्ट इट।
सर जो गवर्नमेंट पेटेंट ऑफिसर्स होते हैं, एजेंट्स होते हैं सॉरी, जो आईपी पे रजिस्टर्ड हैं, क्या उनकी फीस कम होती है या गवर्नमेंट को
देखिए फीस उनकी प्रोफेशनल फीस है, उस पर मैं कमेंट नहीं कर सकता हूँ। मैंने कोई फीस नहीं बोला कितना वो लेंगे, हमारी तो स्टैट्यूटरी फीस है। ओके, जहाँ तक ट्रस्ट की बात है, यू कैन ट्रस्ट देम, दिस इज द वे दिस पर्टिकुलर मैकेनिज्म वर्क। आपको ट्रस्ट करना पड़ेगा, अदरवाइज ड्राफ्ट कैसे करेंगे? अब आप डॉक्टर के पास गए, आपने 2 सिम्टम नहीं बताए तो गलत ट्रीटमेंट होगा। आप भी उन्हें 2 बात नहीं बताएंगे तो आपका गलत होगा। मेन बहुत इंपॉर्टेंट चीज़ है जो आई थिंक पांडे जी टच भी करते हैं कि जब आप स्पेसिफिकेशन फाइल करते हैं, नेवर मिस एनीथिंग। इट्स वेरी डिफिकल्ट टू गेट सर्टेन थिंग अमेंडेड एट अ लेटर स्टेज। कुछ ऐड करना डिस्क्रिप्शन और क्लेम्स में लेटर स्टेज में जो पहले डिस्क्लोज नहीं था ओरिजिनल स्पेसिफिकेशन में, ऑलमोस्ट इम्पॉसिबल है। ऑफ कोर्स सप्लीमेंट्री डाटा है, आप कुछ एडिशनल डाटा दें, दैट्स अ डिफरेंट थिंग। लेकिन अगर आपने कोई पॉइंट छोड़ दिया तो छूट गया, आप नहीं ऐड कर पाएंगे। सपोज कीजिए मैंने प्रोडक्ट प्रोसेस दोनों पे काम किया था, लेकिन मैंने प्रोडक्ट ही क्लेम किया, प्रोसेस क्लेम ही नहीं किया, स्पेसिफिकेशन में प्रोडक्ट प्रोसेस के बारे में ज़्यादा बात नहीं किया, इट विल बिकम वेरी डिफिकल्ट। या फिर कोई इसका ऐसा एप्लीकेशन एस्पेक्ट था जिसको मैंने स्पेसिफिकेशन में डिस्कस ही नहीं किया, अब बाद में ऐड ही नहीं कर पाएंगे उसको। तो लॉट ऑफ केसेस, कोर्ट केसेस आर देयर, कोर्ट ने कहा है ऑफिसर लीनियंट है, बट देयर आर सर्टेन लिमिटेशंस। तो ड्राफ्टिंग के टाइम जस्ट कीप इन माइंड यू आर कवरिंग एवरीथिंग विच यू हैव वर्कड अपॉन।
हेलो,
और ऐसा कुछ नहीं है, आप कुछ प्रॉब्लम हो तो आप बताइए, ऐसा कुछ नहीं है। हाँ हाँ,
स्टार्टअप सर्टिफिकेट में लिखा हुआ है एरोस्पेस, एरोनॉटिक्स एंड डिफेंस, ठीक है। जब मैंने अपने अटॉर्नी को दिखाया तो अटॉर्नी ने कहा कि ये आपका जो स्टार्टअप सर्टिफिकेट है डिफेंस से रिलेटेड है, तो आपको एफईआर में प्रॉब्लम आ सकती है। तो हमने वो स्टार्टअप सर्टिफिकेशन जो है अपलोड नहीं करवाया, सिंपल मैंने प्राइवेट लिमिटेड कंपनी के नाम से मैंने फाइल किया। चूँकि वो प्रोडक्ट रिलेटेड था हमारा अनमैन्ड स्पेस व्हीकल, ठीक है, तो अनमैन्ड स्पेस व्हीकल 12(7) में आता है। तो एफईआर में रिपोर्ट आई कि अंडर सीक्रेसी डायरेक्शन में वो चला गया, अंडर सीक्रेसी डायरेक्शन में चला गया।
डिफेंस में क्या होगा?
अंडर सीक्रेसी डायरेक्शन में फिर ये पूछ रहे हैं कि क्या आप इसको डिफेंस के लिए यूज कर रहे हैं? तो मैं अगर डिफेंस बोलता तो वो मुझे ग्रांट नहीं करते। मैंने फिर उसको बोला
मैं बताता हूँ, देखिए ऐसा है,
सोनली यूज्ड फॉर द ह्यूमैनिटेरियन पर्पस, तब जाके ग्रांट हुआ। तो अब हमें ये बताइए कि हमारे पास सर्टिफिकेट तो है डिफेंस का, तो हम यहाँ पर पेटेंट में डिफेंस क्यों नहीं क्लेम कर सकते?
देखिए 2 चीज़ें आपने पूछी जो अलग अलग लग रही है मुझे। आपने पहले बोला मेरी कंपनी के नाम में डिफेंस था, इट डजंट मैटर आपकी कंपनी के नाम में डिफेंस है कि नहीं, ठीक है?
डिफेंस
नहीं, पहले आपने बोला कि मैंने लिमिटेड किया, ठीक है, मैं दोनों पार्ट कवर कर रहा हूँ। तो नाम से कोई फर्क नहीं पड़ता, आपकी काम में डिफेंस हो या डिफेंस लिमिटेड हो या विदाउट डिफेंस हो, इट डजंट मैटर। टेक्निकल पार्ट पे आते हैं। टेक्निकल पार्ट में सेक्शन 35 हम लोग हैं, मतलब एजेंट ने नहीं कहा, मैंने नहीं कहा, एक्ट कह रहा है कि अगर डिफेंस से रिलेटेड है तो ऑफिस डिसीजन नहीं लेगा। टू वेरी फ्रैंक, इट्स नॉट कि मैं ग्रांट नहीं करूंगा, रिफ्यूज नहीं करूंगा, वो सेकेंडरी स्टेज है। ऑफिस डिसीजन नहीं लेगा, ऑफिस उस एप्लीकेशन को, उस कंटेंट को मिनिस्ट्री ऑफ डिफेंस को भेजेगा।
हाँ, मिनिस्ट्री ऑफ
दे विल डिसाइड कि ये पर्टिकुलर इन्वेंशन जो है डिफेंस से रिलेटेड है कि नहीं। अगर वो कहेंगे जस्ट गो ऑन विद द एप्लीकेशन, वी विल प्रोसेस द एप्लीकेशन, इफ वी विल से इट्स प्रेजुडिस टू द डिफेंस ऑफ इंडिया, वी विल नॉट टच दैट एप्लीकेशन, ठीक है। अब होता है कि उन्होंने लिख के दे दिया प्रेजुडिस है, सुनिए बहुत अच्छा एक रेमेडी भी है डिफेंस के केस में, एक रेमेडी प्रेजुडिस है, आज की तारीख में प्रेजुडिस है। उसमें एक हमारे एक्ट में एक प्रोविजन और भी है, बिकॉज मैनी टाइम्स इट हैपेंस कि जैसे मैं बात करता हूँ ड्रोन्स की बात करता हूँ, ड्रोन्स जब इनिशियल स्टेज में आए तो पर्पजली जो इनका यूजुअल पर्पस था वो मिलिट्री पर्पस था। राइट नाउ आप देख रहे हैं ड्रोन शो भी हो रहे हैं,
बिल्कुल,
ठीक है, बिल्कुल। तो अगर मैंने आज से 10 साल पहले फाइल किया था, उस टाइम केवल मिलिट्री यूज था, मिलिट्री इस्टेब्लिशमेंट ही यूज कर रहे थे, तो हो सकता है मिनिस्ट्री ऑफ डिफेंस बोले नो, राइट नाउ it's falling under defense category, but there is a provision that within 6 months, after 6 months, sorry, you can file for the review of that particular decision. तो 6 महीने बाद आप दोबारा एक रिव्यू डालिए, ऑफिस को बोलिए भाई इसको रिव्यू के लिए भेजा जाए, ऑफिस डिफेंस में दोबारा भेजेगा कि भाई एप्लीकेंट दोबारा रिव्यू चाह रहा है, एप्लीकेंट दोबारा रिव्यू, डिफेंस वाले दोबारा रिव्यू करेंगे. मैनी टाइम्स इट हैज हैपेंड कि आफ्टर अ पर्टिकुलर पीरियड ऑफ टाइम डिफेंस हैज लेटर अलाउड दोज एप्लीकेशंस आल्सो.
तो एज फार एज हमारे केस में मैं आपको बताता हूँ हुआ क्या, जब वो FER आई रिपोर्ट ना, तो वो ऑब्जेक्शन रेज किए हुए थे, तो फिर उस ऑब्जेक्शन को हमने रिप्लाई में हमने उनको जो है बताया कि इट विल बी यूज्ड सोनली फॉर द ह्यूमैनिटेरियन पर्पसेस.
वही मैं बता रहा हूँ, आपके रिप्लाई से कोई फर्क नहीं पड़ेगा, ये मैं बता रहा हूँ आपको बहुत.
अगर मैं कहूँ कि नहीं ये डिफेंस में ही यूज होगा, तो
आपके कहने नहीं कहने से होगा ही नहीं. आपने सपोज कहा कि मैं यूज ही नहीं करूंगा डिफेंस में, लेकिन डिफेंस मिनिस्ट्री को लगता है कि डिफेंस में ही यूज हो सकती है टेक्नोलॉजी, तो दे विल नॉट अलाउ इट. इट डजंट मैटर व्हाट यू आर राइटिंग इट. हमारा एक है ऑप्शन, हम लोग एक इनिशियल स्क्रीनिंग करते हैं. मैं आपको इसलिए बता रहा हूँ कि ऑफिस नहीं डिसाइड करता है, ये मिनिस्ट्री ऑफ डिफेंस डिसाइड करती है जो इस फील्ड को डील करते हैं. वी डोंट हैव एनी जुडिक्शन, वी डोंट हैव एनी से इन डैट. हम केवल स्क्रीनिंग करते हैं. स्क्रीनिंग का क्राइटेरिया होता है, अगर आपने लिखा डिफेंस पर्पस, दैट के इज अ क्राइटेरिया, वी कैन यूज इट टू स्क्रीन इट एज अ डिफेंस. बिसाइड दैट अवर ऑफिसर ऑल्सो रीड इट, कि आपने कहीं लिखा नहीं, लेकिन मुझे हर जगह समझ में आ रहा है. बिकॉज देखिए, जब आप ड्राफ्ट करते हैं पेटेंट, तो जरूरी नहीं है उसमें लिखे मिसाइल है.
पेटेंट की बात नहीं कर रहा हूँ, डिजाइन रजिस्ट्रेशन की बात करो, डिजाइन की बात नहीं कर रहा हूँ.
So I think
पेटेंट के रिगार्डिंग
तो ऐसा करते हैं फिर लंच में, अभी मैं रुकूंगा तो तब बात करते हैं, बिकॉज काफ़ी टाइम है.
postpone for the lunch time.
ओके सर.
तो
मैं सर लंच टाइम में आपसे मिलता हूँ. ठीक है,
जल्दी मिलिए, मुझे ऑफिस जाना है.
नहीं बस मुझे 5 यही क्लैरिफिकेशन के लिए मैं आया.
ठीक है, ओके दैट्स फाइन. नहीं, आप मेरा ईमेल आईडी ले लीजिएगा, उसकी कोई दिक्कत नहीं है. फ़ोन नंबर भी है बहुत सारे. कलकत्ता पेटेंट ऑफिस में प्राइमरली डिज़ाइन का होता है. मैं नंबर कॉन्टैक्ट नंबर दे दूंगा, आप बात कर सकते हैं.
लास्ट क्वेश्चन फॉर
नहीं क्वेश्चन है बाद में. लेट मी फिनिश इट, बिकॉज एक दो छोटी चीज़ें विच आई वांट टू हाईलाइट. आई विल टेक द क्वेश्चन, डोंट वरी. पांडे जी को थोड़ा लंच तक खींचना पड़ेगा और आपको लंच के लिए वेट करना पड़ेगा. डेट्स इट. सो एज फार एज ऑफिस इज कंसर्न, वी आर कंडक्टिंग लॉट ऑफ प्रोग्राम्स for education institutions. Fee is less, as you can see. The fees is equivalent to the natural person, and that is not for filing. Filing से लेके up to renewal fees at every part fees reduce कर दी गई है, which is almost 75% reduction. 1/4 fees होती है natural person की, तो 1/4 है academic institutions की. Okay. Now educational institution क्या है, ये जानना बहुत ज़रूरी है, क्योंकि मैं 3 चीज़ों की बात करूँगा: educational institution, startup and small entity. For to claim all these 3, स्पेसिफिकली जब आप PCT एप्लीकेशन फाइल करते हैं, कुछ भी करते हैं, या इंडियन एप्लीकेशन फाइल करते हैं, तो आपको एक सर्टिफिकेट देना पड़ेगा. आपके कहने से नहीं होगा कि है, यू नीड टू क्लेम इट. ओके, ऑटोमेटिकली आपको नहीं मिलेगा, तो यू नीड टू फाइल दिस पर्टिकुलर. एक आपको गेजेट नोटिफिकेशन यूजुअली देती हैं यूनिवर्सिटीज़. तो दिस इज द डेफिनेशन विच इज प्रोवाइडेड इन अवर एक्ट. यू कैन गो थ्रू इट. आई विल यू विल गेट द प्रेजेंटेशन. तो यू नीड टू प्रोवाइड दैट एविडेंस कि आप एक एजुकेशन इंस्टीट्यूशन हैं. ओके, सपोज कीजिए आप एक R&D इंस्टीट्यूशन हैं, R&D इंस्टीट्यूशन है प्राइमरली, लेकिन आपके PhD भी मिलती है एक पर्टिकुलर चीज़ के लिए, तो इट मे नॉट बी कंसिडर्ड एज ए एजुकेशन इंस्टीट्यूशन, बिकॉज प्राइमरली आप रिसर्च इंस्टीट्यूशन है. तो अगर रिसर्च इंस्टीट्यूशन है तो आपको ये छूट नहीं मिलेगी, चाहे आप PhD के काम करा रहे हों. ठीक है, लेकिन एजुकेशन इंस्टीट्यूशन के लिए पर्टिकुलर डेफिनेशन है. यू नीड टू फॉलो इट टू गेट द इंटाइटलमेंट एज एन एजुकेशन इंस्टीट्यूशन. देन फॉर स्टार्टअप के लिए भी अगेन रिडक्शन ऑफ फीस है. एक्सपीडिएट एग्जामिनेशन का प्रोविजन भी स्टार्टअप के लिए एप्लीकेबल है. स्टार्टअप के लिए ही शुरू किया गया था प्राइमरली. और जहाँ तक लेस ऑफ द अदर थिंग्स आई एम लीविंग. स्टार्टअप के लिए आपको क्या चाहिए? DPIT स्टार्टअप एक सर्टिफिकेट इशू करता है. दैट सर्टिफिकेट इज़ ओनली वैलिड, कोई और सर्टिफिकेट वैलिड नहीं है. तो DPIT स्टार्टअप में आप जाके रजिस्टर कराइए अपने स्टार्टअप को. वो आई थिंक 10 साल का रिकग्निशन होता है. वी ऑल्सो क्रॉस चेक इट वंस यू फाइल योर स्टार्टअप. तो एवरीथिंग इज क्रॉस चेकड. क्रॉस चेक करते हैं, अगर वैलिड सर्टिफिकेट है तभी आपको इंटाइटलमेंट मिलता है. अगर नहीं इंटाइटलमेंट या स्टार्टअप का आपका रिकग्निशन खत्म हो गया है, देन यू नीड टू पे द रिमेनिंग फीस. तो फिर आपको फीस पे करना पड़ेगा. एक और इंपॉर्टेंट थिंग जो यहाँ पे बताना बहुत ज़रूरी है कि सपोज कीजिए आपने फाइल किया एज ए कंपनी प्लस स्टार्टअप, या कंपनी प्लस एजुकेशन इंस्टीट्यूशन, या कंपनी प्लस स्मॉल एंटिटी. अगर कोई लार्ज एंटिटी इन्वॉल्व है तो आपको लार्ज एंटिटी की फीस लगेगी. स्मॉल एंटिटी की या एजुकेशन स्टार्टअप की नहीं लगेगी. अगर कॉम्बिनेशन जो है एप्लीकेंट्स का उसमें एक लार्ज एंटिटी है, तो जो हायर साइड वाली फीस होती है वो लगती है. या फिर लेटर स्टेज में अगर आपने कोई चेंज किया, लेटर स्टेज में सपोज कीजिए एप्लीकेंट ने प्रोक्योर कर लिया, तो आपको रिमेनिंग फीस देना पड़ेगा. ठीक है. अब आते हैं इंडस्ट्री तो इन जनरल है लिखा है, लेकिन मैं बात करना चाहता हूँ स्मॉल एंटिटी की. स्मॉल एंटिटी को प्रूव करने के लिए देयर इज़ ए प्रोविजन ऑफ उद्यम आधार रजिस्ट्रेशन सर्टिफिकेट. एक उद्यम आधार रजिस्ट्रेशन होता है हर एक स्मॉल एंटिटी का. यहाँ पे ध्यान रखना बहुत ज़रूरी है. हम लोग भेजते भी हैं, एजेंट्स, ऑल द एजेंट्स नो दिस वेरी वेल. एवरी ईयर 1 अप्रैल को एक नया स्टेटस मिलता है, क्योंकि एक पॉसिबिलिटी है कि एक कंपनी स्टार्ट हुई एज ए माइक्रो एंटिटी, विद इन 2 years इट बिकम स्मॉल एंटिटी, एंड आफ्टर 3-4 years इट बिकम मीडियम इंडस्ट्री एंड आफ्टर 10 years इट मे बिकम ए लार्ज एंटिटी ऑल्सो. तो एवरी ईयर हम लोग वो सर्टिफिकेट अपडेट हो जाता है अप्रैल में, तो हम आपसे करंट ईयर का मांगते हैं. सपोज कीजिए आपने 1 अप्रैल को अगर एप्लीकेशन फाइल कर रहे हैं, 2 को कर रहे हैं, तो आपको 25-26 का सर्टिफिकेट देना पड़ेगा, जो कि उस वेबसाइट पे ऑटोमेटिकली आ जाता है. ऑफ कोर्स यू माइट बी सबमिटिंग सम डॉक्यूमेंट्स टू MSME डिपार्टमेंट. सो उस केस में अगर वो सर्टिफिकेट पुराना है तो आपको इंटाइटलमेंट नहीं मिलता है जब तक आप करंट सर्टिफिकेट नहीं दे देते हैं. बिकॉज इन लॉट ऑफ द केसेस वी हैव सीन कि कई बार कंपनी इनिशियली मीडियम एंटरप्राइज थी, लेकिन नेक्स्ट ईयर में लार्ज एंटिटी हो गई, तो पुराना सर्टिफिकेट हम नहीं मांगते हैं. अदर थिंग जो स्मॉल एंटिटीज़ केस में हमने देखा है, बी वेरी केयरफुल टू गेट योर these particular certificate, radar registration certificate updated if you are changing your addresses, because state में भी registration होते हैं. और बहुत केसेस हमने देखे हैं कि सपोज़ कीजिए मैं पहले यूपी में मेरी इंडस्ट्री थी, मैंने शिफ्ट किया, या सपोज़ कीजिए दिल्ली में थी, मैंने शिफ्ट किया उत्तराखंड में यूपी में, लेकिन मैंने क्या किया कि जो मेरा सर्टिफिकेट रजिस्ट्रेशन था पहले दिल्ली में था, मे भी अभी सेंट्रलाइज हो, मुझे मालूम नहीं है, लेकिन अगर वो चेंज होता है और आपको अपडेट कुछ कराना है या फिर कुछ एड्रेस चेंज कराना है या जिसकी वजह से वो सर्टिफिकेट होल्ड पे है, तो आप उसको कराइए. क्योंकि अगर जिस दिन आपने एप्लीकेशन फाइल की और अगर कोई डॉक्यूमेंट एग्जिस्ट नहीं करता, मे बी बिकॉज ऑफ एनी रीज़न, तो आपको स्टार्टअप का सपोज़ के 2 महीने बाद आपको सर्टिफिकेट मिला और आपने फाइलिंग पहले की, तो हम आपको इंटाइटलमेंट नहीं दे पाएंगे, क्योंकि आपकी जब फाइलिंग थी वो नहीं था. ठीक है, तो वो चीज़ थोड़ा ध्यान रखिएगा कि फाइलिंग के टाइम वो स्टार्टअप का या स्मॉल एंटिटी का आपका वो होना चाहिए सर्टिफिकेट. तो प्लीज़ बी केयरफुल, बिकॉज हमारे पास बहुत सारी क्वेरी आती हैं कि सर मेरा ऐसा हो गया, वैसा हो गया, मैंने उससे ख़रीदा था, ये किया, वो किया, मैं भूल गया, जो भी हुआ. एजेंट, नोबडी कैन हेल्प इट, नेदर एजेंट नॉर वी कैन हेल्प इट, बिकॉज इट्स ए क्लियर रूल कि यू नीड टू प्रोवाइड द सर्टिफिकेट एंड वो स्टेटस आपका ऑन द डेट ऑफ फाइलिंग होना चाहिए. एक इंपॉर्टेंट चीज़ यहाँ पे जस्ट मैं जोड़ना चाहूँगा. सपोज कीजिए आप स्मॉल एंटिटी थे, फिर मीडियम हो गए, फिर लार्ज हो गए, तो उस केस में भी क्या फीस देना है? तो नहीं, उसमें एक एक्सेप्शन दे रखा है कि उस केस में फीस नहीं देना है, क्योंकि आप ग्रो कर रहे हैं. लेकिन अगर आपने लाइसेंसिंग कर दी किसी बड़ी कंपनी को, तो उस केस में फीस देना होगा, लेकिन आप ही ग्रो कर रहे हैं तो फीस नहीं देना है. एज फार एज इनिशिएटिव आर कंसर्नड, SIPP स्कीम एक मेजर स्कीम है जिसके बारे में भी एक दो स्लाइड में बात करना चाहूँगा. अवेयरनेस कैंपेन की मैं बात करना चाहूँगा. NIPAM करके नेशनल इंटेलेक्चुअल प्रॉपर्टी अवेयरनेस मिशन चल रहा है हम लोगों का, 2-3 साल से वी आर रनिंग इट. पहले केवल ऑफिस कर रहा था, नाउ लॉट ऑफ एजेंट्स हैज़ ऑल्सो बीन टेकन ऑन द डेट लिस्ट, सो दे आर ऑल्सो कंडक्टिंग इट. कोई भी इंस्टीट्यूशन हो, कोई भी अकेडमिया हो या स्टार्टअप हो, किसी को भी किसी तरह का कोई प्रोग्राम कराना चाह रहे हैं, तो वी कंडक्ट कस्टमाइज प्रोग्राम ऑल्सो, स्पेसिफिकली फ्री ऑफ कॉस्ट होते हैं, ऑनलाइन वेबिनार्स हैं, तो यू कैन कॉन्टैक्ट अवर ऑफिस. वो प्रोग्राम आपके यहाँ कराया जाएगा. मिनिमम कंडीशन है कि एटलीस्ट 5-10 लोग तो होने चाहिए, नहीं कि आप अकेले बैठे हैं और इधर मैं अकेला बैठा हूँ. इट शुड नॉट बी लाइक दैट. ऐसा है तो हम सीधा फ़ोन पे बात कर लेंगे, rather than going for NIPAM. ओके, नाउ कमिंग टू SIPP, दिस स्कीम इज़ रियली वेरी गुड स्कीम एज फार एज दिस ऑल द इशूज़ विच इंडिविजुअल इन्वेंटर्स एंड स्टार्टअप यूजुअली फेस द प्रॉब्लम्स. ये स्कीम स्टार्ट हुई थी 2016 में एज ए पायलट प्रोजेक्ट स्पेसिफिकली फॉर स्टार्टअप. इसलिए स्कीम का नाम अगर आप देखेंगे तो है स्कीम फॉर फैसिलिटेटिंग स्टार्टअप्स इंटेलेक्चुअल प्रॉपर्टी प्रोटेक्शन. लेकिन ये स्कीम अब आज की तारीख में एक्सटेंड हो चुकी है, 2026 तक अभी ये स्कीम है. कोई भी स्टार्टअप हो, कोई भी इंडियन इनोवेटर या क्रिएटर हु फाइल्स एन एप्लीकेशन थ्रू TIC आर सर्टेन सेंटर्स एस्टेब्लिश्ड बाय इन India, and any education institution who is filing through a TISC or any eligible Indian applicant filing an international application with India as receiving office or India as ISA can take help of this particular scheme. अब इस स्कीम में होता क्या है? इस स्कीम में होता यह है कि आपको एक लिस्ट ऑफ फैसिलिटेटर अवेलेबल है वेबसाइट, आप एक फैसिलिटेटर को चुनते हैं. That facilitator will help you in everything. First thing, he will advise you, he will do the prior art search for you, then he will prepare the documents for you, he will file the application for you, he will process your application, he will appear in hearing for you, he will do everything for you. और आपको केवल स्टैट्यूटरी फीस देनी है, उसको कोई फीस नहीं देनी है, क्योंकि उसको फीस ऑफिस देगा. Office will reimburse the fees, professional fees to that particular facilitator who is going to be a patent agent or a registered trademark agent by the office. He will claim his fees from the office. This is one of the best scheme which individual inventor specifically used. हाँ, एक मार्केट सर्वे करना पड़ता है, क्योंकि बहुत कई बार हमारे पास क्वेश्चन आता है कि सर ये जो फैसिलिटेटर की लिस्ट आपने दे रखी है, कभी चेक भी किया कौन कैसा है? तो वो भाई मार्केट में आपको देखना है. हमने आपको बता दिया ये लोग अवेलेबल है, यू नीड टू डू सर्टेन मार्केट सर्वे. ओके, आप कार खरीदने जाते हैं तो 50 बार पूछते हैं कौन सी कार अच्छी है. एजेंट का भी पता कीजिए, उनका बैकग्राउंड चेक कीजिए. यू कैन जस्ट चेक देयर इन्वेंशन, उन्होंने क्या क्या फाइल किया. यू कैन टॉक टू द एप्लीकेंट जिनके उन्होंने फाइल किया कि कैसा उनका प्रोसिक्यूशन रहा है, कैसे उन्होंने हेल्प किया. So this is completely free as far as these professional services are concerned. So you can see lot of services are there, from advisory, information, assistance, drafting, filing, prosecution, everything is there. Up to last stage, मतलब फाइलिंग से लेकर जब तक पेटेंट खत्म नहीं होगा आपको पूरी हेल्प करेंगे और पेमेंट हम करेंगे. ओके, और बेसिकली स्टैट्यूटरी फीस लेकिन आपको देनी है. ओके, ये मैं ऑलरेडी बता चुका हूँ. सो जस्ट लास्ट में मैं यही कहना चाहूँगा कि प्लीज़ कंट्रीब्यूट करें इन एवरी एस्पेक्ट. इट्स नॉट अबाउट पेटेंट. लॉट ऑफ पीपल थिंक कि पेटेंट नहीं है मेरे पास, तो गो फॉर डिज़ाइन, गो फॉर ट्रेडमार्क. Contribute in making India a global innovation leader by strengthening the IPO ecosystem, because IPO ecosystem is one of the major pillar of driving our country to as a developed nation. Viksit Bharat 2047. Okay, thank you very much.
Thank you, sir, for your valuable insights. Your perspective has greatly enriched today's discussion. Now, I would like to invite Mr. Gaurav Jain, Chief Financial Officer, FITT IIT Delhi, on stage, present a token of appreciation to Dr. Rohit Rathur. Our next session is titled Demystifying Patentability, Case-Based Insights. It is an honor to welcome our next esteemed speaker, Dr. Sachendra Pandey, Partner for Patents at the prestigious firm KNS Partners. Dr. Pandey is a specialist in the complex domain of life sciences, bringing a unique blend of scientific depth and legal expertise to the table. He focuses his practice on patent drafting and prosecution, managing cases not just for India, but internationally, including PCT, US, and European applications. His work involves regularly appearing before the Indian Patent Office for prosecution, opposition, and appeal hearings, and he is trusted advisor to clients providing expert opinions on patentability, freedom to operate, and infringement analysis. His case-based approach will provide practical, actionable clarity on what truly constitutes a patentable invention. Please join me in extending a warm welcome to Dr. Sachendra Pandey as he prepares to demystify the core elements of patent ecosystem.
Yeah, so thank you all of you for being here, and thank you to the FIT team, and thanks a lot to Aarti Ma'am and Rohit sir. It has always been a pleasure to work with all both of you, with one of the most favorite controllers, in the patent office. Aarti, she is one of the doyens of IP. So we have grown learning from her. So with your blessings. Dr. Agrawal also talked in the morning about how important is IP. I'll just read, what we can already see. Sort of Agrawal said that whatever tangible things we have, bricks, water, all those things, factory, office, they are not that important. As important is IP. And for the people like us who have been in research, who have come from a research background and transited to this side, or the other side, or you want to have a startup, I'll say this one is very important. To achieve patent commercialization success, every inventor must think like a businessman. So probably, it's high time that we change our mindset. So that's very important to have that shift. So कुछ प्रॉब्लम नहीं स्लाइड का कुछ मैं गड़बड़ तो नहीं कर रहा
स्लाइड चेंज नहीं हो, स्लाइड शो नहीं हो पा रहा।
उसको नहीं डालना शी, आपको आपको स्लाइड शो नहीं हो पा रहा।
स्लाइड शो नहीं हो पा रहा है, पर देखना ये सर
इससे करो ना।
हाँ, इन दो से, इन दो एरो से,
इससे और इससे, हाँ?
लेफ्ट राइट।
Thank you, thank you. So we have already heard about what a patent is. Maybe I'll just add one more thing, that it's a territorial right. So you can't say you filed a patent in India, so you've got an overall protection in all the world. So if you want to get a patent protection in US or Europe, you have to file separate patents there, and there are provisions for that. We can go through the PCT route or a Paris Convention route. So note that it's a territorial right. We need to take care of that thing. Malti ma'am has already dwelled on all these things. So what is patentable actually? So any product, which could be a chemical compound, a composition of matter, a machine, so any device, a PCR machine or a flow cytometer or any new device which we make to do anything, that's patentable. Then a process for doing things, method of doing something, method of maybe enhancing the DNA, purifying DNA, or a chemical reaction process, all these are patentable. What are the domains? Like if we go domain-wise, so in biotechnology, we get patents on methods, processes, microorganisms if they are modified. So if they are mutated, then only we get patents on microorganisms. Similarly, on the genes and proteins, if they are naturally occurring, we don't get a patent on them. They need to be, there must be some human intervention. That antibodies and enzymes, we do get patents on them. We'll see in the future slides. So we need to actually define the antibodies in terms of the sequences or the CDRs and all those things, but we do get patents on them. We do get patents on bioformulations. Then if we go on to pharma, chemical, which is the domain of Rohit sir. So formulations, like composition comprising element A and B in specific proportions, we had some question on that also. If there are 2 or 3 components which may be used for treating a particular condition, yeah, that's a composition, we get patents on them. We get patents on new chemical entities, but yes, we need to take care of section 3D, we'll talk about it later. Then kits and drug dosages, these are questionable. So drug dosages, sometimes we may get a patent on that, but not usually. So if we talk about software, we do get patents on methods, processes, apparatuses, devices, means. So, but yeah. So whenever there is a patent on a software per se, so we don't get a patent on a software per se. Algorithms or all these things are not patentable in India. But if we show some enhanced functionality, we show that there is a consonance of a hardware with a software, we do get patents on them in India. Mechanical devices, so I'll say that it's most difficult to get a patent probably in biotech domain or a chemistry domain. But yeah, it's usually easier in mechanical domain. So you would have seen, so when we use scooters, you would have seen a stand. There is a notch to just put the stand in a right place. So one of my friends was attending that hearing. So he told me that just convincing the controller that this notch itself helps us making the scooter stand at a correct position. So that way they could get a patent on that. So it's always most of the times easier to get a patent on a mechanical invention, but many times it is difficult to draft all those inventions. So if we go on to biotech or chemistry, we may have specific set of claims. We may have a claim on a composition, we may have a claim on a compound per se, but to draft a mechanical invention or an electronics invention, that's a real challenge. And that's why, as previous speakers also have said, having a good patent agent who knows about the technology, that's one of the important things. So I will acknowledge that being a biotechnologist, I will not be able to draft a patent on a sort of electronic device or a 6G case. Similarly, they won't be able to draft a patent on a CRISPR or a CAR-T. So we need to approach good patent agents also. So what could a compound claim look like? So it will define the structure. It will define what are the elements there, what are the side chains, and what are the components, how these are attached. So this is how a chemical compound claim would look like. This is how a composition would look like. So usually our controllers will ask for a ratio range of the components in a composition. So to define them well, we need to define the composition in terms of the structure and like the composition and the components in the composition. So if we talk about a process, so for a process, we need to define the process in terms of the steps and conditions. We need to actually, like the Indian Patent Office and the controllers would like us to have proper enablement and tell them that how the process is working, what is the flow of the process, what is the first step, what is the second step, what are the conditions, what is the pH range, what are the temperature range. Maybe this would be a well-defined process claim. How maybe a mechanical invention or a claim would look like that, we'll have to define the device in terms of its structure, how the elements are connected. So we usually have reference numerals there as to how. So this is a claim on a fog lamp, and it tells you that how a reflector is connected to a lens and all those things. So this is how we would draft a claim on a. Okay, so I think Malti ma'am has already dwelled on this. I won't dwell too much on the novelty and inventive step part. Maybe we can go straight away to the. So maybe this one slide and the next slide will alternate. So Malti ma'am was already telling you how to address the novelty. So here you can see that there are lots of fishes, but there is one fish which is which is red or which is orange. So you need to show that how or what is the element which is not there in any of the prior art. Similarly, if we go on to address the inventive step objection. So here there is a fish which is orange also and has 4 fins. So this is how probably you will be able to address the inventive step objection or the non-obviousness objection, that even if there is a crowded prior art, but there may be a fish which has 4 fins, which is not there in the prior art, and that is how they have solved the problem. So having that 4-fin fish as compared to, so this will address your novelty part. So example could be a new chemical entity and a modified chemical entity. So for modified chemical entity, maybe we'll have to address it as per our section 3D. But for inventive step, as Malti ma'am also was saying, the combination of prior art must not make the invention obvious. So do you think this is patentable? Or it just has an aesthetic value? It's not patentable because it just has an aesthetic value. Why it's not patentable? Because it's not satisfying the third criteria. So the third criteria is the invention should also be capable of being made or used or industrially produced. So no one will industrially produce this type of bicycle. Do you think this is patentable? Anyone? So what is this? So both of these are patentable because this is exercise cycle and that is a cycle for cutting the ice. So that is what we always say ki, so we had a case. So we had a case, from CSIR, where the inventors had made or found out a new gene which was inducing stress tolerance in plants. So everything was fine, the gene was novel, everything was fine. But the controller asked us, यार tell me कि ये inventive step का मतलब industrial application कहाँ पे है? मैं क्या करूँ इसका? बढ़िया है, आपने साधन करके दिखा दिया, it's a new thing. But how do you establish the utility part? So until and unless we were not able to show them that it's a transgenic plant and this gene I can transform into rice and make that rice also stress tolerant. Until and unless that I was not able to show that, they did not allow us that patent. So that is why sometimes we miss talking on industrial applicability. It's one of the very important factors which is important to have a patent. So it's one of our favorite cartoons. Do you think anyone will buy this socks? Or is it industrially applicable? It's not industrially applicable. But like someone may just use it maybe for a Christmas celebration or a Halloween celebration. But nothing more than that. It's not industrially reproducible. No one would like to, use it. Another thing, we have always felt, as attorneys also, we have felt that maybe 80-90% of the inventions are improvements over all the processes. So say, for example, you take the PCR. So earlier, like when the PCR was established, there was a problem that we were not able to get like genes amplified or the DNA amplified. So the inventor, like the Hargobind Khurana and all, that team came up with the fact that they combined all those things. They found out an enzyme which was thermostable, and we got a technology by which we were able to produce the DNA in higher amounts. So that was the first thing. Another problem then, now that problem got addressed. Okay, I can amplify the genes now. There were other problems also. The DNA that was being amplified was not of good quality. So then, RT-PCRs and qPCRs came up. Now we have a highly evolved series of PCR things. So that is what we say, that improvements are always patentable, and they help you develop your patent portfolio also. So, and many big companies, they do have patent portfolios where there are improvements. So this is a story of a pen, how that has evolved. So earlier, Rishi Munis used to write with a feather. Then came the lakdi wala kalam, and then came the ball pens. Now we have erasable pens also. So keep improving and filing patents. So that's what is important. Malti ma'am had already touched on that inventions need not be complex. So this person has developed a device where he is also eating and trying to feed his bird. So do you think we need to have such? So we have seen that, some of the most important commercially sellable inventions are most simple ones. Or we have also seen that many times there have been labs. So we were working on a case with Aisar Mohali. So this person or this scientist is from chemistry background. And, they developed a burette and a pipette, so that when we know that whenever we use them, the compounds or the solution spills off. So to avoid them, they had made a very good burette. So that's what I would like to say. There is also not a restriction as to if you are in a field of chemistry, you can't file a patent in biotechnology, or you can't file a patent even in electronics. So these days we are seeing so many inventions which are there in interdisciplinary areas. So, and we always have to develop teams. So whenever such an invention will come up, I will work with some of my mechanical colleagues or from electronics domain. So inventions need not be complex. Post-it story, you already know. So this is also one of the simple inventions. So simple inventions are always patentable. There is no, the three criteria are novelty, inventive step, and utility. Nothing else. So there is no bar on patentability of a simple invention. So this is a pizza saver. This had a patent. It's just a tripod which was used in the middle of the pie to prevent the pizza from sticking to the top of the pizza box. 30-year-old invention, very simple but patentable. So we need to take care in our labs that there are many times we have developed a process which is very easy, which may look simple, but it's patentable. No one would have done that. So similarly, you know, these are some modifications of one thing. So this is a needle which we would use in a home. Then that is the needle which actually brought the, you know, industrial revolution. So that needle was transformed into the leg, and that is how, you know, I think the industry evolved. These are the needles which doctors use in their when they do operate or when they do all those things. Because if they will use that needle, they may, you know, stick some organ or a nerve and all those things. They may destroy something. So all these things are examples of various patentable modifications. Similarly, these scissors, one maybe some of them used in a lab or a barber or whatever. All these are patentable. We need to have insight. So maybe, you know, this is also one of the important things I would like. As I said, that there is no bar ki you are in the field of chemistry, so you can't have an invention on biotech or chemistry or AI. So this invention is for a system of allowing a shoe wearer to lean forwardly beyond his center of gravity like this. So can you guess whose patent is this? We'll go. So this is the invention of Michael Jackson. So this is how he used to do it. So in that shoe, there is a notch which he used to put on the platform. There is a notch on the platform. He used to fix it, and that is how he used to lean on the floor. So that invention is actually in name of Michael Jackson. So there is no bar key. You are from a particular field, you can't file in a different field. So sometimes you do have perceptions. So you would have seen so many of such devices now after COVID. But you know, we had filed it pre-COVID. So this is one of the inventions. This is for our Muslim brothers who do wuzu. They wash their hands and they have to wash their legs also. So this was to help them wash their hands and legs. And the platform used to push the water above. So we now have seen so many inventions after COVID on such things. But yes, so necessity is the mother of invention, I'll say. So that happens. I also would like to talk about this case, you know. So one of these inventors came to us saying that, you know, I want to file a design on this because, you know, this is an ophthalmic, this is a cap for an ophthalmic bottle. They came to us mentioning कि यार मैंने थोड़ा सा modify किया इसका structure, इसका design file करना है मेरे को. So we discussed, we went into more detail, and then we found out that what they had done was that they had put in some gyrations inside the cap. Because of the gyrations, what was happening that only one drop was coming out. So that was perfectly patentable. So we asked them to do both the things, and they got both the both design and a patent. So I'll say that, you know, we need to keep our minds open for that also. There may be cases where, you know, I may get a patent also, design also, definitely a copyright or trademark. So maybe, you know, if we can, so those three are universally important: novelty, inventive step, and utility. But, you know, most of the things, probably in India, are governed by Section 3. So Section 3 talks about non-patentable things. So, and we, you know, we as attorneys, we don't want people to get discouraged. Yeah, Section 3 lag gaya isme. We have ways to do it. And so many times, you know, we have discussed with the controllers and found out ways how to overcome those objections. So for example, I'll give you, maybe you can go through all those, but I'll talk about one invention. So we have a Section 3B which says that contrary to morality or injuries to public health or animals. So there was a device on which we were working, our team was working. So that's a water purification device. Where what had happened that, you know, inventors were using some of the leaves from the plants and as a bioconsortium. So there were layers. There was a charcoal layer, a sand layer, a layer of consortium, and 2 layers of the plant leaves. The controller told us, "यार ये तो मैं नहीं दूंगा, ये तो this is against this is falling in 3B. This is against environment. हमने कहा कैसे सर? तो उन्होंने बोला कि you will be cutting trees for that. So हमने कहा we won't be cutting trees for that. We are using only leftover leaves for that. So that's what Rohit sir was also saying कि you need to develop a camaraderie with the patent office, understand their situation also. We understand their situation many times. Discuss with them. Don't be afraid of the hearings. And there are ways to convince. There are ways to wriggle out. So another thing maybe we can talk about is mere discovery of a living thing or a non-living thing occurring in nature, which includes naturally occurring microbes, diseases, and proteins. We have some 1 or 2 slides later on this also. So I'll say that, okay, we'll go into detail in later slides. Then our section 3D talks about new form or new property or use of a known substance. There are some things on that also. Maybe mere admixtures. Okay, here maybe in this slide I'll talk about mere arrangement or rearrangement of known devices, each functioning independently of one another in a known way. So if there is an umbrella and a torch, and I add them, what will you say? Is it a mere arrangement? Can you do it easily? What do you feel? Can it be done easily? I think it can be done easily. But if you add a switch to it, where the umbrella opens on its own, and there are inventions on that, then there is something additional you have done. It cannot fall under the category of mere arrangement or rearrangement. We will definitely be able to get a patent on that, and we have such cases. We will talk about all these things. We have a slide on traditional knowledge also. Okay, so these are some things which are not patentable in India, method of agriculture or method of treatment, plants per se. So even if it is a transgenic plant, it's not patentable in India. So it may cross the barrier of novelty and inventive stuff, but it may not be patentable because it is not statutorily granted in India. Yeah. GIs are different. GIs are different topics. So GI will be granted for a thing, say for example, you may be knowing basmati or Darjeeling and all. So GI will be granted for so like basmati is a GI for the rice which is long grains and an aromatic flavor. It will be growing only in Indo-Gangetic plains. And that flavor will come only because it is growing in this area. Similarly for champagne, it is the red grapes that are there in the Champagne area of France. Then only like the grapes which are growing there, only will be getting a GI on that only.
Sir, one professor made a comment that because we are working in Ladakh and because it's geographical indication, the geography might change because these days there's a lot of political difference. So, is there another way how we can patent or get the GI tag for Halman apricots?
No, for GI maybe that will be related to geography only. But for a patent, definitely. So you will be knowing there was a case on even basmati rice also.
Yes, I know. Yeah.
So what US was trying to
Rice Tech was doing it.
Trying to rename it and get a patent on that just to push India. But yeah, so they got a patent per se on that rice cell line.
Yeah, Dr. Vandana Shiva is my teacher, so I know.
So, but they could not get a GI tag on that. That's not possible.
Okay.
So we'll talk about section 3D. So what section 3D says is, and it's very important for people from chemistry and pharma background. So it's one of the most important sections which defines our act also. So it says that new form of a known substance. So they are patentable. We have several cases where we were able to show that if there is enhanced therapeutic efficacy. So all of you may be aware about Fitt-Ip case. It's a very famous case. Maybe you can go through that also. So Fitt-Ip case defined that if there is a new form of a known substance. So what could be a new form? These could be salts, esters, ethers, polymorphs, metabolites, all those things. You can get a patent on that. So I'll talk about hope and not the thing that you can't get a patent. You can get a patent on that. Just you need to show that there is enhanced therapeutic efficacy, and that therapeutic efficacy is you should show in an animal model, or maybe humans. So you need to have an in vivo data for that, and that's why we do face problems for applications which have come from outside, because they may not be drafted in the way our patent office requires those, and that is where sometimes we get help of our controllers also. So if you have some additional data which may not be part of the specification, but maybe broadly mentioned the specification, then this has enhanced bioavailability or what type of all those type of things. So we do get help from our patent office. They help us file the data on a sworn declaration that this is the correct and verified data, and we have got patents on that. So having an additional data always helps on section 3D. But yeah, you need to show that there is enhanced therapeutic efficacy. Like you need to have an animal model data on that. So what to do to overcome section 3D? In vivo data must be there. Avoid disclosing compounds not claimed, because sometimes we disclose so broadly. So there is a thin line as to what and how much we should mention in a specification. So if you are not able to enable what you have mentioned or you are trying to claim, patent office may ask us to delete all those embodiments, and that's a loss for you. It's a loss for you because you have disclosed it. You may have got that in a subsequent patent or a family patent, but because you did not enable them, you did not get a patent on that. So you see that, and then your attorney only will help you ascertain whether this may be enabled or not. So and then process patents may be a good backup for strategy. So sometimes big companies, what they'll do, they will build up patent portfolios where they will file maybe 4 or 5 patents on different compounds. They will be filing a patent on a process, maybe on a use. We don't get a use patent here in India, or use or a second medical use. These are not allowed in India, but they are allowed outside. So sometimes that also happens that people come to us, "Yaar, mere paas na, I have a method of treatment, or I have a transgenic plant. What to do?" So we'll say that if you have money, go to maybe Europe or US. You may get a patent on your invention there, but difficult in India. For new use, article synergistic combinations, kit claims could cover scope. Avoid phrases like derivatives, because if you go through the definition of section 3D, it actually says that. So we had a case where just section 3D was raised because the title was mentioning that it's a derivative of something. And when we convinced the controller that maybe they would have mentioned the derivative word there, they did not intend to say that. The compound itself is novel. Then only he granted us the case, but initially they had actually put section 3D there because the word derivative was there. So avoid putting all those terms like it is again struck, I think. Yeah, I think so. I think it's moving now.
No, it's not moving there. एक बार वापस लगाओ सर. HDMI out करो. नहीं, HDMI को निकाल कर वापस लगाओ.
हाँ जी.
गया?
जैसे चैट जीपीटी, डीपसीक वगैरह ये
सुनो, पेन ड्राइव वाला मत ओपन कर दो, डाउनलोडेड
हार्डवेयर के साथ में. बट हाँ, सॉफ्ट देखो, हमारा है हमारे यहाँ पे बोलता है mere algorithm, जो written instruction है, वो पेटेंटेबल नहीं है. बट अगर आप enhance functionality कुछ हार्डवेयर के साथ
कर रहा है कुछ, रुको आ गया.
आपको गूगल माइक्रोसॉफ्ट है, सारे बड़े बड़े क्लाइंट्स हैं या एप्लीकेंट्स हैं, इनको मिलते हैं पेटेंट यहाँ, बट वी नीड टू शो कि वो एनहांस्ड फंक्शनैलिटी है कहीं पे, या फिर कहीं ना कहीं कॉन्सोनेंस ऑफ द हार्डवेयर है, मियर सॉफ्टवेयर पे नहीं मिलेगा, वो सिर्फ कॉपीराइटेबल है. जैसे आई थिंक यू वर आल्सो आस्किंग ऑन AI or something, as you were talking. So as attorney, I would always avoid putting my invention on AI. So there are some AI tools for drafting also, for searching also. Searching is okay, but for drafting, I don't think I will allow any one of my team to use a tool to do that.
I think which slide it was? I think admixture से आगे बढ़ गए. Next और आगे. That was the slide you were on.
Okay, so I was talking about this post-filing data on a sworn declaration. So that is possible if the controllers are ready. We have some support in the specification. A broader term mentioned किया है कि हाँ, there is enhanced bioavailability. So we had a case where we could actually go through, and this case, it was just around the Gleaver case in 2018, and it was on mesylate only. Methyl mesylate का ही compound था. So, and these people had developed a new sort of a isomer for that. We could actually, and Maltinam, we kept that case, dear to our heart for 1 year. Post grant aa jaye isme. So we had submitted a declaration from Dr. Sundar, you would be knowing. So Dr. Sundar, so we had a very good chemist who knows that. So we used his declaration. We used some data to show that there is enhanced bioavailability. It's 50 times more, and that is how we could get through. So there are ways to address all these objections. So many a times in chemistry we do get patents on compositions, and I'll maybe straight away jump to a case which will help you understand as to how we address it. So this was the case way back in, and Rohit sir again, I'll refer to. So this was with Dixit ji. So we had a very reverend controller, Dixit, who is no more. We learned a lot from him. So what happened that this was the formulation. I keep forgetting that. So it was a composition comprising artemisinin. All of us know कि ages से artemisinin has been used as an antimalarial compound, which can be formulated onto granules. So we had combination of artemisinin, piperacin and primaquine. All of these are known antimalarials. कोई doubt ही नहीं था. So, but what was happening कि इसमें the way they had combined it. So what was happening कि usually जो antimalarial drugs हैं बड़ी tablets होती हैं, वो खाई नहीं जाती या उनसे we have vomiting or nausea. So we had a table in the specification which actually showed कि there is a reduction of 50% nausea and vomiting. So sometimes enhanced efficacy can also be seen in terms of reduction in the side effects. So because of that tablet becoming very small and acting very quickly, we could get that patent. But there is a requirement that we need to define the components in terms of what is the ratio proportion. So most of the times, patent office may expect you to put in the ratio ranges if if there is no proper enablement for a broader scope. So that's how we got that through. So for a composition, you need to show that it's a synergistic composition exhibiting unexpected properties, and that is how we could get through this case. So for getting a composition, definitely in the specification you need to have a data on, say for example, enhanced efficacy, reduced side effect, or all those things. Then we'll go on to method of treatment. So most of the times it won't be allowed because you can't grant a monopoly to a doctor for 20 years for a method of treatment. We also understand the psychology behind why that was put in. So for method of treatment, pursue a corresponding mechanism or purely cosmetic method. So as such, in the statute or in the act or in the manual, there is no bar on a cosmetic method. So as long it's a cosmetic method, probably you'll be able to get it. Then stop. So many times what happens that people will find out maybe antibodies which are overexpressed in some type of cancer. So if you draft a claim which will actually say, you know, I am using this biomarker for detecting cervical cancer, there is no chance you will get that. You just probably you need to, you know, just keep short to the fact that you just mentioned that I am detecting this molecule in a sample, in a particular sample. So sometimes the patent office may, you know, borrow your argument, and we actually have got some cases on that. So stop the method before a medically relevant conclusion is drawn. Define, amend the method as an in vitro. So most of the times we would introduce, or the patent office may ask us to introduce these terms: in vitro, ex vivo, ex situ. So as long as the method of treatment is being conducted in body, you are administering something, there is a dosage regimen, there is very less chance that you will get through. But if it is an in vitro thing, an ex vivo thing, an ex situ thing, we have got cases on that. So method of prognosis not explicitly excluded. So again, you know, your attorney will be the person who will actually help you get through all these objections. Claims relating to detection, identification, or use of biomarkers. That is what I was saying, ki you need to just stop from mentioning that it's actually method of treatment, because that won't be allowed in India. That's, you know, maybe unfortunate for us. It's allowed in US. It's allowed in US. So method of treatments are allowed in US. Dosage regimens are allowed in US. But here we don't get patents on that. So we would actually then introduce all these terms: an in vitro method, or antibodies, chemicals, primers used for detecting biomarkers as part of a kit. So yeah. So if there are so many times we would also put a kit claim there. So as long as you are able to prove that that kit is novel and inventive, you may be able to get a patent on that. Just need to convince the controller or mention such things in the specification कि ये method of treatment पे exactly नहीं जा रहा, just a kit है जहाँ पे नए components हैं. Oh yeah. So I'll maybe go to a case. So this is one of the cases where, you know, we had these inventors had developed a percussion solution. So you may be knowing that when we go from one place to another and we have a organ which is to be transplanted from one person to another. So that process of transplanting that organ from one person to another may not be granted in India. And that's what the claim had started. But then, the best part of that claim was that the composition was allowing the organ to stay in viable state for 2 hours. So we were able to convince the controller that 2 hours tak wo stable rehna hai, and we had to actually introduce that an ex vivo method of determining the effects of at least one test substance on a bioactive agent. So method of treatment per se preamble hata ke, we actually modified it to ex vivo method of determining the effects of at least one test substance, and that's how we could get a claim on that. Oh yeah, so this is one of the very, very, a good case we were able to see. So these inventors had developed a sort of a capsule. So that capsule was ingestible capsule. You ingest it, it will go inside, and it will actually monitor as to how much glucose you are having, what type of enzymes are being overexpressed in your body, and all those things. And this will give you a data. And this capsule was actually related to a sort of a system where there was a server, and the data was being given to a data analyst who was sitting maybe 100 miles away. So we had 2 objections on this. So one was method of treatment, कि ये तो पूरा का पूरा मतलब ट्रीटमेंट है कि आप खा रहे हो, इंजेस्ट कर रहे हो, अंदर बॉडी के जा रहा है. Another objection was on 3K कि ये आप तो सॉफ्टवेयर यूज़ कर रहे हो उसमें. So somehow we were able to convince the controller कि यार it is so software per se is not what we are claiming. We are claiming a capsule and a method of transmitting the data. So they got convinced on the part कि चलो section 3 के नहीं लग रहा क्योंकि you are transmitting that data and there is a hardware component also. And then for section 3I also they were okay कि यार चलो there is a device which may be ingested, but you have a claim on a device per se. So that's how we were able to get a claim on that. So sometimes we get complex objections on one case. And so if we talk about antibodies, so antibodies need to be defined in terms of the structure or what are the sites, what are the CDRs, what are the light chains or heavy chains. So probably this would be a standard antibody claim where you are defining a monoclonal antibody in terms of its light chain, its heavy chain, what CDRs it has, how much of functionality it has, threefold functionality it has, like it has a receptor binding capability. So this is how, so whenever there is a claim on an antibody, we would actually define it in terms of its nucleotide or the peptides it has. What could be a microorganism claim? So naturally occurring microorganisms, as I said, are not patentable in India. Even if they are isolated from some soil or some sample, they are not patentable. But if you are able to show that there is some human intervention. So I'll tell you about a case. So, one of the inventors found out a microorganism which was exhibiting hydrogen producing capability. So what they did was, okay, this was a parent claim. They put it in a dairy effluent for 10 days. Post that, they also put that microorganism for 15 days in a distillery effluent. So because of that human intervention, the capability of that microorganism to produce hydrogen became 100-fold. So we were able to show the controller that why it may be naturally occurring, but there is human intervention there. Because we induce those conditions, and because of that, this microorganism is, having that capability. So that's how we were able to defend that case. But yes, if it's a natural or like it's a normal case, you need to define, and most of the times you'll get a patent on a mutant only. But then you need to define that mutant, and you need to also give the deposition details. So this is also one of the requirements when we work with microorganisms. Those microorganisms are to be deposited to a recognized depository, internationally recognized depository. So we have IMTech, we have NCCS, we also have NBIM now. So these are some depositories on which we can deposit the microorganisms, because that will address one of the important objections under section 10. So we have a section 10 which says that your things, your claim should be enabled and supported with examples. And by the virtue of depositing that microorganism, you are fulfilling all the conditions. So this is a brief as to how or where you could get all these patents. So microorganisms, India में questionable है, US में भी अभी questionable है, Europe में allowed है. So even if it is a naturally occurring microorganism, it's allowed. Cell lines India में questionable है, अगर prokaryotic है मिलेगा, eukaryotic है नहीं मिलेगा. Naturally occurring gene India में बिल्कुल नहीं मिलेगा, US में नहीं मिलेगा, Europe में मिलेगा. CDNA definitely मिलेगा, primers नहीं मिलेंगे India में. Stem cell तो questionable है. So vectors, gene constructs, they are perfectly allowable. So vectors, gene constructs, recombinants, they are perfectly allowable. So maybe out of these, maybe I'll tell you about one case. So yeah, so this 25291. So this was one case. I mean I like to talk. So what was happening in this case? There were 4 genes and 2 HIVs, HIV1 and HIV2. So what was happening? Ye inventors ये 4 genes को combination use करके they were able to detect HIV right at the inception stage. So we actually had the objection under section 3I कि method of treatment है. So luckily, you know what happened, and so there has been a change in patent law also recently. We have had an amendment of section 59. So 59 में क्या हुआ कि पहले क्या होता था कि जो claims जैसे होते थे उन्हीं से आपको claims बना के लेके आना होता था hearing में. But now we are allowed to bring in stuff from the specification into the claims to define them well, or sometimes change the scope also. We were able to change the scope of those claims, and we actually got a kit on this combination where we were able to show that with these 4 genes, you are able to detect 2 types of HIV right at the inception stage. So everything is important, how you draft it, what is the data, all those things. I've talked about this deposition of biological material. This NVA thing also is very important for the people who are working in biodomain. So, you know, now the NVA is very active. Patent office is also very stringent on this. So if you are using some biological resource from India, be it a microorganism or a plant or animal, you have to take the permission from NVA. So this is what I was talking about, section 59. So this is, maybe you can go through this case, Allergan case. So this case actually has changed the landscape now. We are able to amend the claims, change the scope also because of this case. And many times things like method of treatment or new use which were not patentable earlier, we are now able to get patents because there is some support in the specification for the fact here I could amend it to a kit or something. So this case has actually changed the scenario. Another case is the Syngenta case, maybe briefly. So what happens that, you know, there is one important objection which comes up is on multiplicity of invention. So one particular application is related to, so a patent office will grant us a patent only on claims which are related by same inventive concept. If they are not related by same inventive concept, they will ask us to file a divisional application. But divisional application also earlier we were allowed to file only from the claims which are on record at the patent office. We are not allowed anything. But because of this case, we are now thankfully able to pull things out from the specification and file divisional application. So as all of us know, it's always good to file a patent first and then publish. So don't fall in the trap of 2P. Go for 4P. Maybe this slide is important to show how much commercialization is important. So for this, just this cap, this inventor, they sold their technology to Coca-Cola and they earned 0.1 cents per bottle. So during the period of validity of the patent, the inventor received 148,000 UK pounds per day. So this is the value of IP. So if you don't do that, you are done. So IP assets, agar nahi hai, so smaller fish gets eaten by a bigger fish by a bigger fish, even bigger fish. But if you have an IP, you can fight back. So that's what I. Yes, please.
Sir, good afternoon, sir. I'm Rachit this side. Hello. Yes, good afternoon, sir. I'm Rachit this side from IIT Delhi. Actually, sir, I have eager to know, after getting patents, so sir, what will be the process of getting royalty?
So various things can be done. What we use, आजकल हम suggest करते हैं कि have your collaborators beforehand. You need to see कि यार ये companies है जहाँ मैं sell कर सकता हूँ. Maybe वो data also you can have in your hands कि यार these are the companies which I need to collaborate with. Another thing is your funding agencies also may help you. So we have several agencies in India. Another thing which we have felt, and I think I heard in IIT Delhi only, what probably you these days are doing is you are collaborating earlier only with the industry, and you have those agreements with them कि यार ठीक है patent we'll also file in US, we'll also file in Europe, bear the charge of the patent, बट वो टर्म्स एंड कंडीशंस बड़े ज़रूरी हैं वहाँ पे लिखना कि यार मेरे को कितना मिलेगा. Maybe you will get 10%, the company, you will get 90%, the inventor will get 90%.
Okay, but sir, someone, like suppose someone, if use my, my idea for making their assets, okay. So, like sir, then it is feasible to check that.
वही है, तो वो जो हम सुबह भी बात कर रहे थे ना कि have those non-disclosure agreements. जिससे भी बात कर रहे हो उससे non-disclosure agreement साइन करना ही करना है, चाहे वो collaborator है, चाहे वो inventor है, कुछ भी है, जो भी है, आपको वो NDA साइन करने हैं, attorney से भी हम भी साइन करते हैं. तो इट्स अ क्लाइंट प्रिविलेज रिलेशन आपके साथ में, हम भी साइन करते हैं. हैव दोज NDAs इन प्लेस, प्रॉपर कंडीशन मेंशन होनी चाहिए उसमें कि रॉयल्टी इतनी मिलेगी, फर्स्ट स्टेज पे इतनी मिलेगी, नेक्स्ट स्टेज पे इतनी मिलेगी. वो कंडीशन जब तक नहीं होगी ना, आप और कहीं नहीं ले जा सकते उस आदमी को सिवाय कोर्ट के. तो कोर्ट में ले जाने के लिए आपको वो रिटन डॉक्यूमेंट तो होना ज़रूरी है. सो वो मैं कहूँगा कि NDA होने ज़रूरी हैं, वो टर्म्स एंड कंडीशन मेंशन होनी ज़रूरी है. और ये भी मेंशन जरूर, कई बार क्या होता है कि अब हमारे पास हमने एक केस देखा कि प्रोविजनल फाइल किया, 2 इंस्टीट्यूट्स ने मिलके प्रोविजनल फाइल किया, डेटा इकट्ठा किया, कंप्लीट के टाइम में दोनों लड़ लिया आपस में, वो कंप्लीट ही नहीं फाइल हो पाया. सो वी वर ऑल्सो सैड कि यार कोलैबोरेट कर लेते, शेयर कर लेते आपस में, तो वो सबको मज़ा आता. बट वो एक मेंटालिटी शेयर करने की वो भी डेवलप करनी पड़ेगी, थोड़ा कॉन्फिडेंस भी रखना पड़ेगा. बट NDA होना बहुत ज़रूरी है प्रॉपर टर्म्स एंड कंडीशन के हिसाब से. और बहुत सारे इंस्टीट्यूट जैसे CSI आ रहा है या PU है, CSR का आई थिंक 60-40 है. सो 60% दे विल डिस्ट्रीब्यूट अमंग द इन्वेंटर्स, 40 दे विल कीप टू देमसेल्व्स. पंजाब यूनिवर्सिटी का आई थिंक 70-30 है. सो 70 दे विल गिव टू इन्वेंटर्स. तो वो कंडीशन और IP पॉलिसी होना आई थिंक बहुत ज़रूरी है. FITG तो बहुत आगे हैं, बहुत इवॉल्व है उसमें.
Okay. Okay.
And rest we can continue the questioning over a lunch. So you can definitely have a discussion with sir for further questioning. So thank you, sir, for an enlightening session. And your practical examples and clear explanations have made the complexities of patentability far more accessible and actionable for all of us. Just 2 minutes, everybody. Dr. Namita is here to give a present appreciation of token to sir. Thank you.
होगा मैं दूंगा आपको कार्ड.
So everyone, please join us by 2:15 again. We'll have a session by Mr. Ronak, and we'll continue the session further. Thank you. चार्जिंग की जरूरत तो नहीं है ना, हो रहा है ना, ये बात तो
लेके आनी है
भी निकाल लेते हैं ना, चश्मा लेना हेलो। पीपीटी मिल गया आपको? पीपीटी मिल गया? हाँ 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 मिल गया, बट अभी लोग नहीं आए हैं सारे। हाँ प्रोफेसर DIRD अभी तो नहीं आया है।
मैम ने लगा दी थी।
2 की लगाई है, तीसरे की नहीं आई।
अभी अग्रवाल
सीए वैभव की नहीं आई है।
आ गई है।
आयुष
हाँ हाँ ये
अच्छा मैंने देखी नहीं, फिर देख लो एक बार।
पेन ड्राइव से मत ओपन
हाँ नहीं
करना,
पेन ड्राइव से नहीं, यहाँ से ओपन करूँगी। ये
डेस्कटॉप पे पेस्ट करो।
एक बार देखना, वही है ना?
अरे
ये है, मैं यही तो बोल
Oh
रही
my
हूँ।
God.
पीपीटीज कहाँ है? ये तो बैकड्रॉप है।
बैकड्रॉप है।
ओके
अभी तो मेरे को मैं वो नाम देखा, वो नाम मैंने लिखे हुए थे, क्योंकि इसीलिए मैं हैरान रह गई थी कि तुम क्या बोल रहे हो। ये है नीचे वाला है, ये नहीं, मिस्टर रौनक वाला ये है। और ये अश्विनी सर का है। ये 2 ले लो। वैभव वाली नहीं है। मैं लोगों को बुला
ये क्यों पकड़ गई थी? मुझे लगा क्या हो?
नहीं मैं देखती ऑर्डर किस किस का है।
लोगों को समझ में नहीं आता। दोनों को पेस्ट करो। अग्रवाल सर का ही है।
एक बचा है बस ना।
ओपन करने का पीपीटी। अब इनका वो लगा दो बैकड्रॉप। और लोग हाँ पीछे ही है। We should start. Okay. We'll be starting in next 5 minutes. Just please call all your friends or your colleagues who are there with you.
पीपीटी नहीं आई है इसमें सीए बैक ऑफ जेल अग्रवाल सर की आ गई है एक बार खोल के देख लें कंफर्म कर लेना क्योंकि वो ना फ़ोन में मैम कह रहे थे कि अग्रवाल सर की नहीं आई है या पता नहीं आई है एक बार किरण मैम से कंफर्म कर लेना किसकी नहीं आई है बाकी तो सब क्योंकि इसके बाद शायद डायरेक्टर भी आ जाएंगे 4 बजे या उन्हीं के साथ आ सकते हैं
स्टार्ट करें Good afternoon, everyone. Let's begin our next session on navigating innovation insights from the industries. Our next speaker, Mr. Ronak Muzib Kasir, has 22 years of experience in the semiconductor industry and currently works with ST Microelectronics. He leads startup scouting and collaborations across India and contributes to R&D efforts in system solutions for AR, VR, and robotics. Please join me in welcoming Mr. Ronak as he shares industry perspectives on navigating innovation. So,
This is working?
Yeah, this is working. You can just
This
switch
also?
it. Yes, both are working.
Okay. Hello. Hello.
Just switch it on.
I'm not putting my specs so you can दिखेगा नहीं चश्मा छोड़ दिया. Hello.
Just 2 minutes, sir. It will take time to
Okay.
get it on. 2 minutes it will be.
Fine. Okay, it's okay. Hello. Yeah. Good afternoon, all. Thanks, Fitt-Ip, for inviting me, and it's an honor for me to stand here and speak about navigating innovation. Is the topic was shared to me to talk here. I come from a company by name ST Microelectronics. Hope I'm audible. Fine. Raise hand if I'm not audible in the back. And we are a semiconductor organization developing chips or silicon. You may know Intel, Broadcom, TI, so we are in the same league, B2B. So before we go further, what is innovation? So any idea? Can we have some answers from anyone? Some things find new. Good. Any other? पूरी दुनिया को बदल दे. Very good. One. Sorry. Very good, sir. I think this needs a clapping first of all.
So that's the difference between invention and innovation. So invention is whenever you make something new, it is an invention for sure. But if you're not able to bring economic value, or sir said commercialize it, तब तो कोई invention ही रहता है. Okay, mix of Hindi, English is okay. So till that time, it is only invention. Good to have in your records, in your merit. Oh, I did 10 inventions. When innovation happens, it happens only when you are able to bring economic value or bring business, commercialize it, bring revenue. That's the innovation. So this is as much a tedious task for startups as for big organizations. So that's why I put these two exclamation and hash, because nobody knows still who are working for 50 years in the same industry how the new product would come. I don't know if you're following Intel and AMD. So Intel, so when I was born in 80s or 79, 70s, still we had Intel processors. We had the ad Pentium 2, Pentium 3, and all. I don't know if the young generation would have seen this ad or not. But today, if you see, there's a big challenge to Intel. Are you aware? Who is giving challenge to Intel these days? AMD, correct. So for 40 years, Intel was this here and all other were here. And many companies like ST wanted to enter the processor business. Everybody burned their finger. After 4 years, they left that business and came to the traditional business. AMD kept on targeting them. Still, Intel has that, brand value, Intel inside, and people purchase by default Intel laptops, and they don't purchase AMD. Only engineers who know the specs, they purchase AMD. I'm just sharing that that's the challenge of innovation. So 50 years, they were ahead, but suddenly AMD kept on persisting, kept on targeting them. They left Intel behind in the server business. There are two businesses, processor and server. They left Intel behind the server business, and now they're eating up their processor business. And Intel, they invested a lot on the processor and didn't invest in the industrial and the other segments, like what Texas, Broadcom, or MediaTek do or does. So that's the innovation or the persistence, management commitment coming from AMD that is able to get business now from the processor also. I'm just sharing, nobody knew who will be able to target at that time Intel, but everybody tried, and one company who kept targeting, at least they're getting the fruits. So that's the innovation or the benefit of innovating and persistence in that business. So again, so innovation is a very good term, and even when I was born, it was talked in 1950s, 1940s in American literatures of academic literatures. You know this company 3M? Do we use any of their product in your home? Can we name 2 or 3? Fevisticks, cleaning. जूना आता है ना, बर्तन वाला, Scotch Brite. It's a 3M. That was a waste coming out of one of the product of a 3M. Somebody said, "जूना अच्छा होता है, बर्तन अच्छे धुलते हैं," and they made a product out of this. So you may be laughing, but this is the reality how 3M works. So the 3M has a rule. 15% or 15% employee would spend in their own time to create a new project out of their in their business line. So that is the management commitment I'm sharing that has. It's not only management, employees, how employees are contributing to their organizations. So innovation is a very good word to talk about, but it comes with a cost, with a commitment both from employees and from the management. दोनों को साथ चलना पड़ेगा तभी innovation होगा. I cannot do alone. If I am Ronak in ST Microelectronics, I can try n things. If my management is not supporting, or vice versa, management saying do innovation, will do this, that. If I'm not willing to do, it won't work.
So 3M is one company. They started it in operations in 1902, long back, and it is one of the most innovative company in the world. So if you see Larry Wendling, he talked about, we do think innovation is more than an accident. So it's a practice. So in industry also, when we say develop product, we are told to develop product, but it's a practice. So we have to practice that innovation. We have to keep our antenna open. What is something new? If we're doing something new, document it and discuss it. How it can be made useful for the organization. So it doesn't happen in an isolation. You have to document. You have to think, oh, I'm writing a piece of code. Is it innovation? Can it bring value? Can it be my IP? It's not about always big technologies. Anything what you do is an IP. Another example, this is the famous example, Apple. You will be using some of the products. Do you know the pain point of Mr. Steve Jobs? He was thrown out of his own company because he was not able to commercialize or bring value to the company. He made a Mac, it was very costly. Their partners, they said, you're a bad person, you just go out. And they threw them out of the company. So that's the story of Steve Jobs. So but he focused on the innovation, on the usefulness. So today you have iPod, iPhone, and iPad. It started with iPod. What is iPod? And was something available before that also? Something around typical? No, that Walkman is with a cassette. MP3 player. So MP3 player was also a digital player, and they also made a digital player. What was the difference? The looks, design, number of songs. They purchased some rights from the company who made music. So they organized it. The look and feel, the sleekness. So what sells in the market? Technology never sells in the market. Technology is hidden inside something. Technology is there, but for a common person, do I appreciate what is inside this technology? If it doesn't work, if it doesn't look sleek, nobody cares. You would be very passionate about, I will be very passionate about my technology, my company. But as a purchaser, as a buyer, you don't care of technology. You care how my phone looks, how good looking it is. That is the technology. Technology has to be hidden, and on the front it should be the beautifulness, the elegance that comes in the product. And so this gentleman did. iPod, iPhone, iPad. Everybody has, they have the same, okay, I can say at least in the phones what you are using, we sell sensors or chips to them also, to Oppo, Vivo, Samsung, everyone, we sell the same silicon from the same fab. It's the same gyroscope accelerometer that rotates your mobile phone from landscape to portrait. But they do something more beyond that. They try to extract more juice and give you something more use cases. If I sell you, this is a silicon, this is a chip, it does landscape, portrait, it doesn't bring any value for you as an end customer. But the moment you realize in a product, give some use case, something real that is affecting your life, helping you, that becomes innovation, and then you're ready to pay for iPhone or even the smartwatch also. So we have to see from that aspect that innovation is not only invention, innovation is the outcome, the persistence, the patience, the value, the effort that goes beyond in the innovation is a very long one. So I was just preparing this slide, just thinking what is the definition of innovation. You see, I have just put till 1998 here. But if you go to the definitions in the history of literature, it starts from 1934, 1950. There were some academicians who gave definitions for innovation. And if you club all of them, all talk about degree of newness and degree of usefulness. One is how much new it is, novelty, and does it bring economic value. So it talks about novel, economic value, replacing the existing product or process or business model, whatever it is. Everything is innovation. It's not, it can be tangible, non-tangible. So why innovation is important? Is there only three things or something more than this one? One is adaptability. Innovation helps you to adapt in bad times. You work in any technology, any product, you will find at least 5 competitors working with you across the globe. आप कुछ भी कर लीजिए. You make a sensor, you make a chip, you make a product, you make a phone. Somebody across the globe would be working on that subject, of course. So innovation, if you have the IPs, it helps you adapt. You have the core thing. Once you have the core, you can make changes and adapt with the competition, with the timings. Growth, it brings economic value. If you see, there would be organizations or companies or startups with one IP only, they would have scaled up. There are many companies now people are working on AI. In AI, there are many startups working on AI. With few products around the AI, they are able to scale up. Why? Because they have the IPs. And unique edge, it gives you an edge in the business from the competitions. So in this competitive world, you need to have an edge. Edge on the IP side, on the product side. How will you get the edge? When you have innovative things in your product. So these are important key or important elements in innovation. Of course, there would be many. I would be love to hear from you also if there's something coming in your mind also. Of course, at the end, innovation is here to bring the growth, the business value for the organizations. Have you heard this kind of innovations, the different types of innovations? Open innovation, have you heard about open innovation? Linux. Linux is not an open innovation exactly. Okay, so open innovation is a new term coined lately in 2006 or 2003 time frame, where they talk about collaborative working. Let's work collaboratively because the technology is very deep and nobody is expert on each subject. So bring the complementary thing together and let's try to bring economic value that helps to bring business for each other. Like if we say EV, I cannot be a battery expert. I may be a motor expert. I may be an application expert. So let's work together to reduce the time cycle. If I make a EV, as example, I will take 5 years if I have to do battery, motor and everything. But the moment I say, okay, I will focus on this subject and then I will bring all my partners who are expert there and we try to do something in 1 or 1.5 years. That is open innovation. Then we have sustainable innovations. Nowadays, we talk a lot about sustainability, of reusability, recyclability. So, that is one sustainable innovation is coming up. Then we have grassroots innovation. Any idea what is grassroots innovation? Yeah, very good. Exactly, locally made solutions coming from the local requirement, not from the price point of view, from the local community point of view, what is helping the people in the local community. Then we have a famous term called disruptive innovation. Everybody talks about disruption kar diya market mein. And sometimes it is very loosely talked about, or for everything we say disruption is in the market. But if you go by literature, disruptive is a relative phenomenon, not an absolute phenomenon. When we say it's with respect to some relativity is there. Of course, it brings a challenge to the incumbent who are already doing something, but it is more or less relatively term used. And then we have a reverse innovations. So if you see here, the innovations happening in developing countries, and then it is brought in the developed countries. So there are different types of innovations happening in the industry also, and working on this also. So how do we do innovation? It can be a product, innovation in a product. It can be in a process, in a service, in a business model. Any further idea where innovation can come? If I miss something? What is the example of a product innovation that comes in your mind? Apple, iPhones, okay. Process? Sorry? Not Coca-Cola, is not a process can be there. Yeah, that was a process innovation. A kind of say business model, a process. They had the product. How you are able to minimize the warehouse cost? As you order, you get something and you pay and go ahead. So they're saving money in the warehouse and all those things. The process or a business model. Service? Zomato, Blinkit, yeah, all are. Yeah, you're right. All are on the innovation on the service side. How you're innovating there, and this needs to be protected. So I think in the previous talk we had discussed about these things. So I will not discuss, but we have these 4 categories typically: patent, trade secret, trademark, copyrights. Generally, most of the technology companies go for patent, but sometimes tech companies also go for trade secret. They don't want to reveal at all how they have developed. Okay, there are use cases like initially when we used a pedometer when you have it's a smartwatch. Some companies went for trade secret not in these days, in 90s, because they were able to track the floors also. One is walking on the horizontally, on which floor you are walking. So they used some sensors and they never filed a patent, because when you file a patent, you know what you have filed. When you file a trade secret, it is never known to anyone. I never want to know, like Coca-Cola, it's a trade secret. I don't want to know at all. Then we have copyrights and trademarks. So I will not go beyond this. I'm just sharing that these are the different tools we have for saving our innovations. Of course, all these are are limited to the geographies. So if a patent is in India, it may not apply in America, in Europe. So you have to file multiple patents. But this helps as a tool to protect our innovations. These are some of the sites where you can see the patents. I will skip this one because there was a talk before this also. So how do we do innovation? The previous slide you need? Yeah. Okay, these are open website where you can see all the patents. So generally what patent attorney says that before you come to us, go to this site, see what you have done and what is available. When you go there and see what is available, then you come to know what you are proposing, is it patentable also or not. So you get an idea also. Can I move? Oh, okay. So what is the process of innovation? कैसे innovate करते हैं? Yeah, tell. Yeah.
So in order to protect the harvest and to reduce the perishability, we came up with a solar dryer in Ladakh. It's called as SAK.
Okay.
So for us, sir, it was need and crisis based.
You are right, ma'am, and most of the innovation happens on a need only.
Yeah.
So I was saying to one of the girl here, okay, so that there's 2 things. One is making and one is selling. You can make all great things, but is there any customer willing to pay for that? I give example from ST Microelectronics. We were once upon a time, we were leaders in set-top box business. You had that set-top box business, still you have that Den box is there for the set-top box, for the satellite TVs and all those things. So we took pride in saying that, we are the best set-top box chip provider with these technologies. But we failed in China and India because India need only one thing, transmission coming in and going out and we are viewing something. They didn't need all those extra features that this technology company used to provide. And then we had challenge with a Chinese company who did in a very 1/3 cost. So we had a great technology, but we never flew because we were not selling in the right place because we didn't have the buyers. Our buyers only we don't look for recording also. Only we need something is coming, I am able to see 100 channels, that's all. So ma'am is right, so need should be there. You can make tens of things, but unless somebody is willing to pay for that, you will be good in invention, but not in innovation because there's no economic value. So that is the first thing. Business, somebody is going to buy, there should be a need. Then innovation is a culture, it's a mindset. You should have a calculated risk-taking attitude, resilience, and investment of time and money both. So for startups, these are little bit ambitious, but even then, for a longer run, you have to have these kind of mindset or this kind of mindset or mindshare when we work for innovations. The startup may think that big companies have these luxuries. We also don't have the luxury in big companies also. They're also the same purpose. Oh, just finish this product and start a new product. So it's challenge everywhere. We go to all the global companies or big, small companies, that's the same story. But we have to invest time, and as an organization, sooner or later they are realizing that they have to focus on innovation because now they are facing challenges from the startups. So let's focus, let's give time what we innovate, and these are something, it should be top down. What is top down? Coming from the management. Management is having view, no, we have to put 20% in innovating, otherwise we will perish in 10 years. And of course, we will find a history of companies who had come and also gone. Bottom up, employees are the most important asset for the organizations. So we need employees who are dedicated and working as an entrepreneur in the organizations. We call it intrapreneur, INTRA. So who are there, who take benefit of this framework, policies coming from the organizations, top down, and contribute. So it's a both mix of top down and bottom up. And of course, this design thinking is one tool for innovation. It talks about empathize, define, test, prototype, and ideate. So there are 5 steps to understand what we need and what we do. Now I understand some startups are here. So why do you think that all VCs, private incubators, or deep technology companies want to work with startups? Any idea? Young blood, yes sir. Creativity, agility, innovative. Competition, yeah, the competition there also. There's a big inertia in the big organizations. They don't want to take risk. If something is selling, let it sell. Because nobody wants to become a bad boy in organizations. Okay, let's stop something and do something. So, and nobody is sure which thing will fly. So nobody wants to become a bad boy. So let's keep the face clean and still see. So that's why they look for startups. And so ST also is doing, it's not only others, we are also doing the same thing. We are also looking for startups who are working on technologies, evaluating them, supporting them. So innovation is important because there's inertia in all the big organizations. There's inertia to innovate, not to innovate, to go in a new subject. That is inertia. So they wait to see which startup is doing there, and they want to learn from the startups. Before they do their own move, they want to see, okay, you have invested 3 years in quantum or in heterogeneous integration or some other subject. Share your experience. We want to know what we have done, and we'll see how we can work with you. So they want to learn from the startups because rather than burning their fingers. That's why for startups, it is good that you innovate. Think of a IP coming from your side. कोई ना IP जरूर होता है because just how you think. It can be a piece of code also. Anything can be IP. So think and protect your IP and do share this IP. Do talk about this IP. Why this is important for your startups. So technology, revenue, IP. So there are the three things. Why incubators are after startups. So. So innovation is important for startups, and this is the reason why big companies or incubators looking at startups, because big companies look for innovations to remain healthy and for longer life, because sometimes they cannot invest. So what should we do? So it should be a practice. So as a company, when as a startup, small, big, whatever company, as an individual also, if we are in academic, we should practice innovation. We should discuss with our colleagues. The more we discuss, the more we practice, and the more we try to bring something new out of discussions. It can happen at all levels. It's not कि CEO or CTO ही करेगा. That's not their job. They are mostly facing the investor for whom they have taken the money. So at all levels we have to work, and with the right framework and policy coming from the organizations. And every company, even my ST company, is putting organization framework policies to promote people to come forward and innovate and put value for the organizations. And read what your competitors are doing. Don't assume that I am the best, I am doing the best. Everybody feels what I have thought, जो idea है ना, this is the best idea I have. Believe me, everyone gets 100 ideas every day. How you implement, what is the outcome, that matters a lot. Ideas everybody get, ऐसा कर लेना चाहिए, but नहीं कर पाते हैं. So Apple did that. You had an MP3 player, you had a digital player. How did they package it? Slim, good looking. Even see the box of Apple, how it opens. Slowly it opens, if you have felt that. So you take care at every moment. If you have used Nokia mobile phone, I don't know how many have used Nokia in the olden days. That was the perfect model of innovations. You drop it from here, still it works. So that is the something innovation. That is the faith on you, on the brand you have. So you have to work. You have to understand what competitions are doing, and you have to be going ahead of the competitions. And that's the last slide. As I mentioned, we have a program called ST for Startups. So we do work with startups. We provide technical supports. We don't take equity. We don't give equity. We are like a technology partner. We look for system startups. System startups are those startups who use our ST chips and make solutions like on robotics or any applications. And we also do look for silicon startups who want to make their own chips. On silicon startups, we have access of fab. So if you have some idea, we help you in manufacturing in our fab the prototype or the test chips that can be used. So these are some of the advantages we have here. So in terms of technology, we have a program called multi-wafer programs. It's called MPW, where we help in developing a silicon. Then we have tools and talent. We have a concept of innovation manager, where if we select you, we help you in developing your product. We assign a right technical person for your applications who can guide you on need or case basis. At the end, but the product remains yours, your IP remains yours. We never own those things. That's all from my side. Thank you.
Do we have any questions from the audience?
Thank you.
Thank you.
I'll keep it here.
So just do this.
Yeah, you can switch it to.
Okay. Thank you, sir, for offering valuable insights into how industry drives innovation and startups to transform ideas into impactful solutions. I would like to now invite Dean IRD, IIT Delhi, on stage and present a token of appreciation to Mr. Ronak. So coming up to the next session, our next session takes us through the full innovation life cycle, the startup journey from lab to market launch. It is a privilege to introduce our distinguished leader who has been instrumental in shaping this journey of IIT Delhi, Professor Ashwini Agarwal. He is the Dean IRD at IIT Delhi and is the Chair Professor of Smart Textiles in the Department of Textile and Fiber Engineering. His research excellence is reflected in over 120 international journal publications, along with his leadership of the Center of Excellence in Smart Textiles, Smita Research Lab. Professor Agarwal not only holds several national and international patents, but has also played a key role in transferring indigenous technologies from lab scale to Indian industry, actively bridging research with real-world impact. His deep hands-on experience in innovation, R&D, and commercialization makes him the ideal guide for this session. Ladies and gentlemen, please join me in welcoming Professor Ashwini Agarwal to share his insights on the startup journey from lab to market launch.
Thank you very much for inviting me to present my point of view. Though I'm not really an expert in actually market launch, but I can share my experience how to take it to that level. Then obviously a lot of things happen in market which you know, which you need to learn, and everyone has to approach the market in a different manner. My experience in last 30 years in developing technologies at the lab scale with my students and team and looking at what we can do with it, few successes I have found along the way and many challenges also. So I'd like to just throw the few points towards you for thinking about it. Let me ask you, how many of you are working as a startup? Can you raise your hand just to have an idea? Okay, and how many of you are mentors for startups in this? Okay, great. And university professors or teachers and things like that? Great. So we have a mixed crowd. So I will talk to you from various aspects. Let me just first tell you what has been my little experience in few slides so that you can have a taste of it. But I will leave that after that, more of a discussion from your point of view. What is that you want to know as far as I am concerned, what I can do as a justice to this thing. So this is my little journey. These are not all the technologies we have developed or transferred. These are some of the few which we have done. So to Indian industries, which is the mandate of IIT Delhi faculty, we develop technology to try to give it to industry. So we have been successful in making N9 Blue Silver, which has been commercialized. SRF Limited, we have done various technologies and they have been upscaled. Mahle Filters, Austrian company, we have done efficient fuel oil filters. JK Papers, very recently, we have transferred them to technologies. And they are being scaled up right now. I happen to also get involved in 3 startups with my students. The first one, NanoClean Global, it's 2016, has raised 2 rounds and is now in a slightly good position money-wise, sustaining itself. Incipient Materials, we have reached the market launch level, and Navitha, we just started last year, and we are in the level of making MVP so that we can show it to the investors. So the N9 Blue Silver, just few glances. I will take only 2-3 minutes for this. This is the technology we transferred. It's pure silver, okay, which looks blue, right? So it has a lot of technologies involved in it. And company today which got this technology is using it in over 100 brands all over the world, right? So these are some of the examples. So if you go to these stores, you will find this technology being used. You might be already using these things in your daily life. So a lot of things which have been launched by this company as a finish to these materials. So you have to look at the symbol N9 on the corner. So anything which is, this is the second technology which our startup did, which is naso filters. So if you are you don't want to wear the whole mask, half mask, you can wear nasal filters. Based on that, we have now come up with, this was through COVID time, which we did, but now we are into window screens, industrial filters, high efficient industrial filters with very low pressure drops, etc. And very recently, the company has launched something called Siggy Bud. Siggy Bud is a filter which you put behind your cigarette, and it captures all the nicotine in it. So at different levels, 30, 50, 80%, it takes out the nicotine. So there's no product in the world which can actually absorb nicotine. Tar, yes, not nicotine. So the idea is to make people go out of smoking slowly, taking them off the nicotine levels. We have done fuel filters where efficiency have gone up. These are not air filters, these are fuel and oil filters, which are very, very different technology altogether. This is something which we are building now. It's a smart socks for gait analysis. So you wear the socks and you just walk, and it tells you how you walk, how you're walking. So this video just tells you. So the person has worn these socks, and there's a tablet which is just collecting data of pressure and the time with how the pressure is changing on both the feet. So this can tell about your abnormalities, your mental, physical, orthopedic abnormalities, rehabilitation. So there are a lot of applications which we envisage. So today we are working with AIMS, with Safdarjung hospital to validate this technology vis-a-vis their labs, gate labs, which almost cost 3 to 5 crores to set up. This thing is under 1 lakh rupee. So the other thing which we are doing right now is making skill-based technologies where surgeons can develop skills for operations. So you know, most of the surgeons in India, they go and practice right on the patient, right? In a staged manner, obviously, in the presence of senior doctors. But it's a high-risk situation. You can't do that for pediatric patients, especially newborns. So we have developed models for newborns where a surgeon can actually practice, improves his or her skills, and then goes for a further training into an operation theater. This model has been showcased around the world in almost 8 or 10 countries by now, and people have bought it right out. So it's not a very high-selling, volume-selling item because it is very specialized, but people who really appreciate this, they just buy it. So from surgeons from Japan, UAE, Philippines, Turkey, Israel, you name it. I mean, there are many countries where this thing has gone, and in India, obviously. So we have developed many such products. So this is just to give you what is that I have tried to do, my students have tried to do, and as companies we have tried to do. What has been, and what I thought have been the challenges. What do you think? What is the first challenge when we are in the lab? Can anyone say and share your experience? Yes. Problem identification. So that is the journey where you have to start. Whether something requires the market fit or something like that, yes. Once you have identified that, what is the challenge then?
Making somebody else believe that this will actually solve the POC.
Yeah, even before that, what is the problem? You have to first actually do the experiments. You have to be in the lab. You have to buy materials, raw materials, synthesize them, make them, produce them, make a material and then characterize it. Now, characterization is not so easy. It's not that you have made something and you can prove it. You said, who will believe it? So, who will believe that I have made something? Unless until you can show that, see, these are my results, these are my strength, these are my modelage, these are the stability against the environment, whatever, or these are the sensitivities. For example, the socks which we are talking about, they require sensitivity in picofarad level, right? And stability. So those socks you can throw in washing machine, take it out and again wear and walk and it will give the same reading. Whether that is possible, you have to actually do those experiments. You have to actually show that under the conditions of use, it is reproducible, right? So that is the first challenge, and that is the technical challenge. So first is the lab work, which comes. And the lab work means you have to look at the technology, how to do it, how to manufacture it or synthesize it. You have to go to the literature maybe, find various reactions, do them, maybe take help of people who are good at science and engineering to find those. You have to make sure it is unique and innovative. Otherwise, the value is obviously not there. It should solve a problem. That means someone should know it. Very, very important is you may have done it once, you may have done it twice, and third time you do it, it doesn't happen, right? Because you did not realize the factors which are affecting the output of your technology. Things can happen, has happened in my lab that something happened in summer did not happen in winters. Because the student did not take care of the temperatures at these two points. Both times the reaction was being done at room temperature. But the room temperature itself has changed by 15 degrees or 20 degrees. And things did not materialize, right? Moving from a small beaker to a slightly larger beaker, the heating pattern, the stirring patterns, I mean, anything can change and it will change your output. Whatever you can do in a small beaker, you will not be able to scale it up, say, to a half liter or a 1 liter also. I'm not talking about scaling up, actually. I'm talking about lab scale scaling up, very small. It will not happen. It will not give you those results. You had 90% conversion, it will drop down to 60% conversion. And the whole thing will become non-repeatable. So you have to look at, so you must spend time here, otherwise, when you have grown ahead, and then you will realize that things are not happening for some reason. And whenever and whatever solutions you are bringing, you have to see every component cost. So you can't buy a chemical which is extremely expensive, which is 5,000 rupees a gram, and you're doing a reaction. Or you're buying a component out of China or out of USA or somewhere where the material cost is very high. Not only that you have to import it, but you may not be able to feasibly use it. So every type you have to see how much you are using and what is happening, and then you have to verify whatever you have done with a third-party testing to ensure that whatever you are doing is actually correct. Then comes the patenting and protection, which you just said, right? And I think since morning you have been hearing that protection and how to find IP, so I'm not going to spend any time on IP. But protecting it early is very, very important. So if you feel you have reached a stage which is unique and novel, go for a patent. Now, let me ask you what you understand by patent. Now you have been trained well, right, since morning. So how does it protect you? How does it help you? Is it that nobody else can manufacture it?
To preserve the commercial rights?
It is only that, yeah, preserve commercial rights, but is it that you will be able to stop others from producing it? Or innovating on your patent? Not at all, because you have also innovated on someone else's patent. It is a journey which has started from some concept and people have been just putting one more aspect and technology is changing. So do not ever think that if you have patented it, nobody else will produce it. Rather, if you patent in India, everyone else will produce it everywhere else in the world, right? Except for India. So, but why is patent important then? So you can't stop others from producing it. So why it is important? Credibility, and? No, you can't. You can't. Money is coming from marketing, right? And you can sell it.
Nobody can copy your idea.
No, they can. How would you prove they have not copied your idea? Suppose you have made a formulation, a chemical formulation. You say, this is my compound, I have used these 5 things. They work like this. Someone else makes it. How do you prove he or she has not copied you? So it helps others, right? How does it help you? The better you make the patent, more information put in it, more dangerous it is. Right? Give you a different? For raising money. See, the only thing I learned from my industrial partners, so I was very worried, patent. He says, why are you worried, patent? Patenting does not sell anything. You should know how to sell it first, right? But where is the patent important? Patent is important that people buy it from you because they feel you have not copied it from somewhere else. Because there is a liability to the buyer also. If you have copied someone's technology and you have sold it to a buyer, to a customer will not buy it because tomorrow the liability may jump to the customer. So it is just to protect your customer and be faithful that, yes, what I'm buying is original. It is not copy. That protection is very big thing. As you said, I mean, it gives value to your product. This is the value. You are giving a guarantee that what I'm selling you, you don't have to worry about others filing cases against you, right? But other than that, there's no value of patent, but this is the most important value of the patent, that you should have it, right? National, international. One of my companies, initial company said, yeah, it's such a good technology. We went ahead and filed patent in 5-10 countries. And then, no money, right? Every country is so expensive. Filing is the cheapest thing. Maintaining is, and actually granting and maintaining is most expensive. And especially if you go outside the country, it is extremely expensive. We decided not to continue with any of those patents except for 1 or 2, and India. So you have to very judiciously, I told you, you cannot stop anyone from copying it. But it gives you a power to sell. So even if you're patented in India, you establish your origin. Everyone else is copying. So a US person may be, or a Chinese person may have copied your invention, may compete with you, but he or she may not be able to say this is original. You will be able to say this is original, and that brings the value to your company and startup. So that is the value. So you don't need to really worry about international unless until you are really going to do a lot of international business in a particular segment, then you have to worry about international patents as well. So this you must be hearing, right, in the morning. I mean, most of my talk is actually kind of you already know, right? But who are the users? What are their pain points? And how do you address them? This is where the innovation comes from, right? When you are actually developing a technology, do you know answers to any of these 3 questions? You do? Then great. But most of the time, actually, you have thought of something, but it is not really needed in the market, right? For example, when I made sensors for my socks, okay, I said I'll make sensors. I'll put them in my bed sheets for patients with diabetes, with bedridden patients, and they will have this or that. So we made sensors, and I started approaching companies. I said, I want to integrate on bed sheets and mattresses. He says, who will buy it? I said, you are selling so many mattresses and so many beds and other things. He says, L1, okay, nobody wants to give even 500 rupees more, and most of the beds are sold in government hospitals, right? I said, private? He says, they buy it from outside. हमारे बेड तो उनको पसंद ही नहीं आते. So you forget about that. So the market is very, very small. So we thought we had done something, but actually there was no need. Once we figured it out कि हमने बना लिया. तो आपको क्या करना है? This is what I learned in my US trip. US trip is when I did my PhD in US. So professor came and he said, you develop a technology and then you sit down and find the uses for it. Because that same technology can fly in many directions. It is a concept which you have developed, and you can find different uses. And if you look at your journey and journeys of your senior startup people, you will find they have started with something, they ended up with something else. Most of the time. They probably would have failed. For example, nasofilters, it was a demand, and we actually put a lot of money and a lot of effort in putting nasofilters into the market. It went viral into the country. But people just did not accept it beyond these couple of months of pollution. After that, the company had no business. 2 months, people are buying it. After that, there is no sale or hardly any sale. On the web, Amazon, anywhere. I mean, it is there. You just put nasofilters, you'll find it. So, but slowly we evolved into industrial filters. Slowly we evolved into industrial filters. Now we are today talking to Blue Star and things like that. So our journey has turned in various directions. We hit market with the smokers, which we said, are we helping them to smoke more? Or yeah. So it's a dilemma. So as a businessman, such dilemmas will come to you, and you will not be able to see, and I address this question very, very easily. It's an evolving question. But you have to have understanding of what is the novelty you have got. Now, one of the problems I have understood with the younger generation, they feel they've got an idea, They've got a technology. Now my job is to raise money and market it. Get it contract manufactured and market it, right? They do not pay attention to the technology at all. Professor ने develop कर दी, मैंने किसी से करवा ली, मुझे किसी company ने बना के दे दी. I mean, these are, I hope everyone understands Hindi here? Yes, everyone? Okay. So, I'm cool. I've got a programmer, he or she is programming, my product is ready. It will fail. It will fail 100%. Why? What do you think? What may be the reason? No, even before that. You don't know how to do that again yourself with your own hands. That person leaves, technology is gone. Right? The professor has done something to you, you want a small modification to it, professor says, sorry, I'm not available anymore. Gone. Unless until you have a hold on your technology, your company will not survive few years beyond that. This is happening to one of our company. Now, they did not increase the salary of one of the person. I told them, please take this person, he's going to, he developed a lot of products, did not increase his salary. He left. Now he's back to me again. Sir, बनवा दो. मेरे पास भी नहीं है. मेरे पास बनवाने के लिए कोई नहीं है. No team is there. Why should I keep doing the same thing for you again and again? So you have to have a hold on your technology. Hold वाला थोड़ा सा आगे भी आएगा slide. I'll skip that then. So you got it. So you should know what is unique in your technology and how you got it. And what is the fundamental nature of it. Even if you know someone can make it, most of the entrepreneurs are not able to explain the technical significance of their technology to an investor. ऐसा नहीं कि investor जो है उनको बड़ा समझ में आता है. उनको gut feeling होती है कि हाँ अच्छा लग रहा है. हमारे investors आए ना वो ऐसे ही आए. अच्छा है. वो नहीं बिका तो तुमने मुझको धोखा दिया. अरे भैया तुमने समझ के पैसा लगाया, हमने थोड़ी जबरदस्ती तुमसे पैसा ले लिया. अगर आपने नहीं समझा तो आपकी प्रॉब्लम है, राइट? हमने तो अपनी तरफ से सब कुछ समझाया आपको. प्रॉब्लम क्या है ना, इन्वेस्टर को समझ में आता है ज़्यादातर, ना जो टेक्नोलॉजिस्ट है या जो स्टार्टअप है वो ही समझा पाता है अपनी बात को और समझ पाता है. बट इफ़ यू आर good in your technology and you understand your technology, then you're on a good footing. If not, you must capture that first. Okay? One of the startups in my family collapsed after reaching a very good level in Bangalore. It collapsed because it's heavily dependent on 2 programmers. And these programmers took the company on ransom after that. After a few years, they started demanding things. 12 बजे आऊँगा, 5 बजे जाऊँगा, जो करना है करूँगा, मुझसे पूछने की कुछ ज़रूरत नहीं है. और आपको नहीं चाहिए, मैं जा रहा हूँ. आप बताइए, now you will do what that person wants you to do, right? And this will not survive. You will not be able to go and for a very long time again. Then comes the upscaling problem. This is the pain, right? Once you have done a technology and you know you can make it, I'm talking about simple chemical technology, beaker technology, okay? Mix few things, make something out. Or develop a product, whichever way. You need to see what are the techniques you have used in making it in the lab. Lab, you have all kinds of machines. You can do it. Industries, those processes are not necessarily there. You may use E-beam epitaxy for making your sample. It's not going to be a viable upscaling option for you. It may be, you may do scaffolding, layer by layer depositions on your material to get some property. Extremely slow processes. Commercially, they're going to pain a lot, and your cost will rise like anything. You need to see the process has to be friendly to the industry. Very, very important. Okay, very, very obvious. You should be able to source the material at commercial level, right? It should not be a research chemical or a research material which is available in small quantities at a high price. It should be available to you in hundreds of kgs and thousands of kgs depending on the scale in which you will have to move, right? And it should remain procurable. You should be able to procure them easily. This I have already talked a little bit, right? You have made it, crafted, handcrafted it. Now you have to make 100 pieces. Handcrafting is out. How do you make it again? How do you reproduce it again? That becomes a challenge. And so properties like how it's dispersed, whether it's happening at the large scale, I have already talked to you about it. But other than that, once you have even developed it and maybe you have used chemicals and the processes very well, not necessarily you can package it well. For example, we made a very good finish for our textile material. Very wonderful finish. It works very well. But we have to apply it as we make it. Which means if I have to send it to a company, I have to send it in a diluted form, which can be applied. It's a non-commercial business because you're paying a lot of money in transporting water as a dilution. And no company will take tanks and tanks of it and put it in their manufacturing line. They would like to have concentrated material which they can put 1 kg in 100 kgs or 2 kgs in 100 kgs or something like that. But then if we make it at a higher concentration, it precipitates. It doesn't work. We are not able to isolate it. We are not able to stabilize it. This is very, very important in nanotechnologies area. You can stabilize something at 0.1%, 0.2%, 1%. You make it 3%, 2%, it precipitates. It doesn't remain there, right? So a lot of things which we have to see whether you can isolate it, package it in the concentrations where the companies can take it, okay? And then it should be stable. You should be able to store it for 6 months, for 1 year in a good